Hmm.
Lordships take the entire execution case of the decree holder.
Yes.
Only on the ground, my lord, that substitution has not been effected of the two judgment debtors, although your lordship has agreed that merely because non-substitution, the matter may not be, my lord, abated.
What do you want?
I only want upgradation, my lord.
Hand over the slip. Upgradation, please hand over the slip mentioning the urgency. But you have to serve notice upon the other side. Please don't hand over the slips where you have not given notice to the other side.
No need of
Notice for that.
but serial number 118 in the monthly is a
Expeditious hearing.
Expeditious hearing, hand over the slip.
My lord, may I, my lord?
Expeditious hearing, hand over the slip. Section 24, Civil Procedure Code, please hand over the slip. What is the item number?
271 in the monthly.
271 in the monthly list.
Extension, you want a battery?
Please wait.
Last week when I mentioned, my lord had asked me to effect service upon the other side and come back. My lord, it's an application in which an order,
What do you want?
my lord, for upgradation.
Please hand over the slip mentioning the urgency, provided you have served notice upon the other side.
Lord, may I, my lord?
Please hand over the slip mentioning the urgency.
There was an order to the matter to appear as teacher's motion.
Yes.
Lord, may I have your lordships kindly, my lord, to have your lordships leave, my lord, to file this revision application without certified copy.
What is the extreme
Lord,
urgency?
urgency is, my lord, Commercial Court, my lord, Alipur. Lord, is proceeding on a day-to-day basis with respect to hearing of
That is the object of the act.
Yes. There is no difficulty on that. I have a demurrer application that this is not a commercial suit. Without hearing that, Lord, occupational charge is being, Lord, heard out. On a
Can you not
day-to-day
file
basis.
with the certified copy?
Lord, certified copy on 14th we had applied, till now we have not got.
Leave to file. Leave to file with the server copy.
And Lord, only
without
one
the certified copy. Leave to
Lord,
file without the certified copy.
before 24th, any day, Lord, subject to your lordship's convenience. Before
Mention the date in the presentation form, it will appear on that date.
Obla.
Listened by the mic.
What do you want?
Only
Upgradation. Please hand over the slip mentioning the urgency. Please hand over the slip mentioning the urgency
Listed motion, my lord.
for inclusion.
For inclusion.
My lord, a title suit was filed against the defendant, my lord, a company, my lord, that must be the petitioner company.
What do you want?
My lord, for listed motion, my lord.
Hand over the slip for listed motion. You don't have to mention.
Well, may I be?
Please hand over the slip for inclusion of
Item number
listed motion.
297, well, tomorrow is the date fixed for all of every.
What do you want, Mr. Chakravarti? What update?
2 p.m. No, well, 2 p.m. because tomorrow is the date fixed for evidence. Well, already three adjournments has been sought for. The landed advocate has informed.
What is why did you mention last Wednesday?
Last Wednesday it was mentioned, my lord.
If you have mentioned, please inquire.
Has been carried 2 p.m. my lord.
Mr. Chakravarti, if you have mentioned in the last week, all slips were
It is
considered.
appearing, but my lord, it is not, my lord. My lord, kindly appreciate, my lord.
No. But it has been mentioned which you have mentioned in the last week. In all matters, dates have been fixed. Please don't mention again. Then it will be delisted.
Application, my lord. It has been dismissed by default by the other court, my lord. Let it appear in
When it was dismissed for default.
on January 2025, my lord.
Application monthly list.
My lord, my lord,
Yes.
leave to mention a matter, my lord, the interim order was there, it will expire, my lord, on 30th of June. Matter is appearing in the list, my lord, as item number, my lord, 1, 2, 3, 4, if lordship may consider.
Interim order is till the end of June.
Till the end of
So
June.
please mention for extension in the next week. I will
Next
take
week.
up.
Very well, my lord. My learned junior will mention the matter,
Yes,
my
yes.
lord.
Give notice upon the other side. Ask your junior to give notice upon the other side.
Certainly, you would give notice.
May I be permitted to mention one matter?
What do you want?
For inclusion, yourself. It's a division bench matter. Rule has been issued against the alleged contender on this.
Hand over the slip. Division bench did justice.
Supratim Bhattacharya.
It will appear on Friday. Please hand over the slip.
May I have your lord?
Matter is the interim order is about to expire. Malad had the occasion to appear for one of the parties in the matter. Malad, if Malad keeps it for tomorrow,
To be mentioned tomorrow.
there is
Malad.
two more. I would like to also mention. This is for a cooperative society. Malad, there's a clear
What do you
bar.
want?
Malad, I am suffering an execution
What do you
order.
want, madam?
Malad, I want an upgradation.
Please hand over the slip
Also,
mentioning the
Malad,
urgency.
this is about a custody matter, Malad. I'm challenging a.
Please hand over the slip.
Mentioned this matter several times, Millard. It is imperative that Millard kindly upgrades this matter. The matter has not seen the
Madam, please hand over the slip mentioning the urgency. I'm considering each and every slip the urgency.
Telling us item number 1570 in the combined monthly list. And my predicament is that the interim order shall expire by the end of this month, 30th June.
Hand over the slip.
I've handed over and copy already served.
All right.
My lord, for inclusion, my lord, this matter, my lord, a new matter, my lord, for inclusion. My lord, 2024 matter, my lord, it went out of the list, my lord, I am mentioning for inclusion.
Why it went out of the list?
My lord,
You did not appear.
my lord, that day, my lord, something happened, my lord. That is true, my lord, but it is in December, my lord. I am mentioning now in June, my lord, at least, my lord, praying for an inclusion.
Inclusion.
My lord,
I have indicated the urgency.
Yes.
that in my eviction suit, there was an application being moved by the.
But he is mentioning, please.
There is an application being moved by the defendant for actually allowing his.
What do you want?
Why not for inclusion? Because on February,
Hand over the slip.
stay order was granted and
Yes,
thereafter
please.
matter was.
Inclusion, please hand over the slip. You don't have to mention. Inclusion, upgradation, please hand over the slips. Mentioning the urgency.
Passed an order, Lordship had passed an order directing the to be listed as a contested application.
Contested application, please don't mention now.
For directing to appear as contested, it is
It's not possible to take up contested application now.
list.
Monthly list also, the matters which are in the contested application could not be reached. Then I can fix a date, but motions will not be taken up. Choice is yours. I have no difficulty in taking up. So you consult amongst yourselves, give me a specific date, time. I will take up contested application. No difficulty on my part. I love to hear contested applications, but motions will not be taken up. Choice is yours.
Sir,
I appreciate, sir. Unnecessarily adding in the list will not help. Please see how many contested applications are there in the monthly list. Cannot be helped, cannot be touched. Please wait for some time. Let me see how far the motions.
sir, Lord,
Passed, my lord, in the matter in October. Copy served on us in May. My lord, the interim order actually had expired. We had taken out an application before the tribunal for adjustment of the sale proceeds. Though there is no stay continuing, the tribunal refuses to pass any order because the order was passed in October.
So, please impress upon the learned tribunal that the law says otherwise, unless there is a, got that no urgency, yes.
Kindly have this
My lord, may,
Will be listed. Please hand over the slip.
স্যার লোয়ার কোর্টে স্যার কালকেই স্যার ফাইনাল আর্গুমেন্ট আছে, তারপর স্যার ফাইনাল অর্ডার বেরিয়ে যাবে, তার আগে কাইন্ডলি আমাকে একটা স্টে অর্ডার করে দিন
Please
স্যার।
hand over the slip, yes.
my lord, may I be permitted to mention one matter in person, my lord? Upon notice, I'm mentioning, my lord, CO 571 of 2024. I'm the petitioner in person, my lord.
Yes.
Your lordship, in spite of your lordship's order, Mr. Arunangshu Chakraborty is still refusing to hand over the NOC Wakalatnama, and that is why I'm
There's a procedure, Mr. Ghosh, there's a procedure prescribed under the appellate side rules. Please follow that.
my lord, my lord,
Mr. Ghosh, for cancellation of Wakalatnama, there is a procedure prescribed. Please apply that.
my lord, despite the undertaking,
Right.
Mr. Chakraborty,
An order, please take steps in terms of
because my lord, there was no specific direction, and my lord, I pray that
please,
you kindly appreciate my predicament.
please follow the appellate side rules. Please take steps in accordance with that.
My lord, there is no specific direction. That's my only
indicated
humble submission, my lord.
Hand over the slip. Yes, Mr. Chatterjee.
My lord,
with respect to item number 145, I've heard your lordship, my lord, for handing over the slip, and I'm sure it's been handed over. My lord, there is extreme urgency in the sense I can't enter my flat. The Waqf Tribunal says,
Mr. Chatterjee, in the evening, I go through all the mentioning slips. You can ask the junior to check up if it was mentioned earlier, what is the endorsement. All the slips are preserved in a file. You can check up.
Just one prayer, my lord, before your lordship kindly looks into it. I can't enter my flat.
Surely, if it has been handed up, it will be looked into. Please tell me tomorrow if it has not been looked into.
I'll
Has been handed.
I'll try. The other one is item number 1553. Here also, my lord, the problem is the arbitrator is proceeding. Your lordship directed me to serve. I have served and I have come back. Your lordship did not pass an order of stay, my lord, saying that nothing will happen. Now, my lord, the arbitrator in Delhi, my lord, he's trying to, my lord, proceed with the matter. Kindly, my lord, if your lordship
Hand over the slip.
It's been handed over to your lordship.
Yes.
my lord, I'm mentioning. My lord, I'm mentioning a matter for arbitration. It is in the monthly.
Please hand over the slip.
I have
Mentioning again. Please, if you have handed over the slip, please don't mention. And if you want to already physically mention, all right, I can take up the mentioning up to
it is pending since 2013, my lord.
Please mention the urgency. I have to consider the instance urgency. All that will be updated.
May I be permitted 12 of 2024?
Please mention the urgency. I will consider.
Lordship, may I be permitted to mention a matter? Lordship, this is one of the specially assigned matters out of the bunch of 3 matters on the issue of preemption with respect to Bastu land. We have served notice, my lord. Your lordship has heard, sitting with Justice Partho Sharuti Sen. Lordship, possibly a bench has to be constituted. This last, your lordship has heard it on December 2024.
এদের সঙ্গে একটা
May I be permitted to?
Very good.
What do you want?
The petitioner is not having water.
What do you want, sir?
It is updated in the list.
Hand over the slip.
188, but
Hand over the slip.
I'll fix the matter tomorrow to PM, my God.
Please hand over the slip. I will fix the time.
May I be?
Yes.
My lord, item number 173 of my lord's today's list, my lord. Why I'm mentioning, my lord, this matter was not adjourned at my instance. At the time when the matter was taken up, the opposite party appeared without caveat. My lord directed to serve a copy. I have served, my lord. But the matter is not retained position, my lord. And the difficulty is that, my lord, the matter is fixed at argument stage before the learned district forum, my lord. So, my lord, that in sometime in July.
Mention that in the mentioning slip. What is the date fixed? Hand over the slip.
My lord, mentioning from the daily item number IT 67, my lord, the impugned order challenge has been passed by the Election Commission of Cooperative Society. My lord,
What do you want?
my lord, kindly fix the matter today or tomorrow.
Hand over the slip.
Your lordship, may I permitted to mention a matter?
the matter is appearing in the daily list as 314. Every day it is appearing in the daily list, but it is beyond the 300.
Hand over
So
the-
kindly upgrade it. It has been since 2024 December.
I think upgradation is to be stopped now. I have to proceed serially. I think that's the best thing.
Lordship, it is been from December.
Like, so I will proceed serially. Then you are upgrading, mentioning some matters. I think I have to stop upgrading. I have to proceed serially. That's the best thing. It will not go down then. I think that's the best thing. We have to proceed serially. I'll consider that.
May I be permitted to mention this matter, my lord, where I'm praying for leave to move this application urgently because the next date is fixed on 21st of this month. My lord,
Please file.
My lord, the direction has been passed to the IC of the Bardhaman police station to produce the minor girl to the court, my lord, without hearing the petitioner, my lord.
File. Mention the date. It will appear on that date.
My lord,
Why do you need leave?
Yes, my lord, Saturday is the date, my lord.
Please file it. You mention the date in the date of listing in the presentation form. It will appear on that date.
My lord, a restoration application was filed. It was supposed to appear on the daily list, but it has not come. May I mention it for inclusion? in the-
Daily list.
I mean, yes, my lord. In the list.
Also, it was supposed to appear in the daily list.
In the list, my lord.
What if, from where you got that information that it will appear in the daily
It
list?
was supposed to be included in the list.
Say so.
Yes, sorry.
Hand over the slip.
With your kindest liberty, may I
Thank you,
mention
Madam.
that your lordship would remember this is the second expeditious application. The first order was given by Honorable Justice Shortcut to be finished within 6 months. Thereafter, 2 years passed. Then
What do you want?
Milord, for inclusion in the daily, your lordship would remember the file could not be located at.
Not in the daily list. It will appear in the monthly list. Inclusions all in the monthly list. Yes, hand over the slip. Yes, not in the daily list.
Lordship's daily list.
Item number
265 of Lordship's daily list. I am mentioning on behalf of the opposite party. The judgment letter.
Have you given notice upon the petitioner? Yes.
Upon notice, I am mentioning that I am entitled to a decree of 18. Execution proceedings are pending, and if every order that are coming up before Lordship, and the matters are getting delayed.
Hand over the slip. Yes.
May I have your lordship's kindly mention your item?
Part heard on 16.5 regarding provisions of the Limitations Act.
Part heard?
Yes, your lordship.
By me?
Yes, your lordship.
I have not made any part heard.
One day
From my date of delegation, not a single matter I have made part heard.
on 16.5, your lordship.
Show me the order.
Order. Please.
পাঠায় লেখা আছে পাঠান
Yeah, part heard.
সেটা বলুন জজ সাহেব বলছেন উনি কোনোদিন পাঠান করেন
Limitation last in the last occurrence, your lordship.
Where is the order making it part heard?
জজ সাহেব তো শুনেছিলেন পাঠা সেটা
I have not made any matter as part heard.
Your lordship. Regarding for the last 25 years, your lordship, kindly appreciate.
That is a different thing. You have said I have part heard.
No,
I have not
one
made a
order.
single matter as part heard. The first thing I am hearing from you. Hand over the slip. Hand over the slip.
Kindly appreciate.
item 6 proceed this I am the mother
What do you want?
Mukherjee paid for time for the opposition.
What do you want?
My daughter is to go for higher study to America, but I'm not.
Sir, what do you want?
Upgrade as a husband.
Keep mentioning the
It's
article.
1 crore salary, I'm getting 1 lakh maintenance.
Please hand over this.
So I mentioned couple of times.
1 lakh is not sufficient for you.
Study his her daughter, his daughter.
All right. Please hand over.
Couple of times will kindly appreciate.
Last Wednesday we have handed up.
That. Last month I mentioned it.
Have you asked your junior to see what is the endorsement there?
It was not upgraded. It was not upgraded.
So, considering the urgency, it was not upgraded.
But this is the it's not kindly appreciates. I studied
Mr. Chakraborty, I have to consider the inter-se urgency.
I understand.
All
but
matters cannot be upgraded.
somebody comes and pays for time and then the matter goes down, but I'm suffering.
Please hand over the slip. Yes.
Matter is fixed for delivery of possession with the police help. Your lordship 26th June. Your lordship,
When it has been fixed for delivery of possession?
6th June of 2025 with police help.
6th June.
26th, 25th June.
25th June. You have mentioned in the last week.
And allow your lordship for matters appearing 197 of the daily list, your lordship, for I'm paying for upgrade.
197. Come at 2 p.m.
Okay.
197 to 2 p.m.
Kindly have to mention the matter here.
Yes.
May I have your lordship's kind leave to mention a matter, your lordship, item 223 and 224. Your lordship has passed an order on 6th of May 2025,
Yes.
saying that the matter will appear on 14th May. Since at this stage I have not inclined to grant an interim order, since the matter is appearing on 26th of June before the trial court.
Yes.
But the matter is appearing for final hearing on 26th of June.
Please hand over the slip mentioning the address.
Permitted to mention, but this matter was directed to appear as contested application.
Contested application, it's not possible now. Please wait for some time. Interim order, hand over the slip for extension of interim order.
Yes, but that I am.
So give a slip for extension of interim order, not as contested.
Learned court below has his last chance for bringing order from the Honorable High Court, my lord.
What is the date fixed?
27/6/2000.
Hand over the slip.
My lord, may I be permitted to mention?
Have you mentioned the urgency, the date?
Yes.
May I be permitted to mention, my lord, this pertains to section 7172 of the Premises Tenancy Act, my lord. Now, my lord, my defense has been struck off, my lord, challenging that order, my lord. We have come up before your lordship. Now, my lord, the matter is fixed for arguments. The matter was firstly fixed on 13th.
Where it has been fixed for argument?
My lord, lastly, it was fixed on 16th, and now, my lord, what I have been informed, it is kept on Friday. So,
Friday?
Yes, my lord.
Where it is appearing?
My lord, item number 190 of my lord's list.
Supplementary list?
Yes, my lord.
2 p.m.
Lordship, may I be
190
permitted-
come at 2 p.m.
May I be permitted to mention one matter, Lordship? For child custody, Lordship, I have filed 6 years minor child, Lordship. I am coming from Bombay to Dakshin Dinajpur every single day from past 3 years. The wife is adjourning the matter and delaying, Lordship.
Hand over the slip.
Thank you, Lordship.
In the lower court, because they wanted to proceed if I don't do same.
All right, hand over the slip.
Lordship, may I be allowed to mention this matter? It was already admitted on 28th April. Lordship, looking at the urgency, fixed it for 6th. We have already served.
Hand over the slip. Hand over.
Lordship, may I be permitted to?
Mr. Alda.
The interim order was granted till end of June.
Till end of June.
And another I am paying for expeditious disposal. One interlocutory application is pending for last 5 years before the
Hand over the slip.
It is running in the list, my lord.
Your lordship, may I be permitted
Lord,
to mention for an extension of interim order?
Hand over the slip.
It has been expired. It was till the end of May, your lordship.
Hand over the slip.
Your lordship, may I be permitted to mention for inclusion?
Hand over the
My lord, may I
slip. Are you changing sides, Mr.
because
Chakra?
I thought this will be not some kindness will come, but here the father is for custody. No custody has been given. In court, 1 hour has been given. My lord heard me. Somebody appeared, prayed for a copy. My lord directly it will appear as at the list on 6th of May. Thereafter, it is not appearing. I am not getting him in custody. Kindly have a look at the last order. And
All right, hand over the slip.
May I have your lordship's kind leave, my lord, with regard to item number
Item number-
74 of the days list.
Item number
74, my lord, of the days list, my lord. My DW has been closed and 23rd is the date fixed for argument, my lord. This was taken up by your lordship, my lord. Mr. Chattopadhyay is appearing on behalf of the opposite party.
74.
74, my lord. This is the last order, my lord.
70. What is the next date fixed?
23rd is the date fixed, my lord, for argument.
Kalke 2 p.m. করে দিন. Tomorrow 2 p.m.
My lord, may I be permitted to mention a matter for inclusion? My lord, this matter is for expeditious.
Hand over the slip. Yes, Mr. Ghosh.
Expeditious since 24, Lord, the partition suit. That is, Lord, commission submitted report. Lord, you examined for 3 years.
It's appearing in the list. Inclusion. Hand over the slip for
Item number 318. Running in the list, today list.
What do you want?
My lord, kindly fix that tomorrow.
Hand over the slip. Let me see when I can fix.
My lord, for inclusion tomorrow.
My lord, last
2 p.m.
Wednesday I mentioned the matter without notice. Today, my lord, I am mentioning with notice. The police have allowed no stay granted.
Hand over the slip.
And another connected matter for arbitration, which is running in the month.
Hand over the slip.
May I permit to mention one matter, lordship, for upgradation item number 1456. The precarious situation is that, lordship,
Please hand over the slip mentioning the urgency.
item number 1246 of the monthly.
Upgradation. Hand over the slip.
This application was filed.
What do you want? Upgradation.
Lord, it was filed, Lord, my lord, the Ombudsman was pleased to observe that it should be a civil revisional application. Department was directed to amend the construction, and it has been done. Lord, I am just handing over the slip and may it appear as a motion.
Yes, please hand over the slip.
My lord, kindly to mention, my lord, for upgradation.
Hand over the slip.
However, my lord, there is an urgency, my lord.
Please mention the urgency in the slip. Hand over the slip. Yes, Mr. Banerjee.
Last condition was not complied. Last condition admitted this was not complied. So lordship asked. So lordship extended.
Hand over the slip. No, there was an interim order. Till which time the interim order is there?
No, that is
That is in June.
and your lordship order was complied. We have given notice to the other side. But in the evening, come under the extension of interim order, your lordship.
Only extension of interim order. It extension of interim order.
With your lordship, this is a matter which I mentioned. Your lordship on 6th of May says that at this time I'm not passing interim order since the matter is on 26th of final hearing. So I mentioned I'm giving the order and the urgency I mentioned. But we kindly list it before.
Yes, Mr. Banerjee.
Lord, day before yesterday, an accommodation, very embarrassing accommodation was paid on my behalf. I had gone for a medical checkup due that it was the 9th 2 p.m. matter. The list collapsed slightly, Lord. I could not make it. It's a very urgent matter. It came at 2 p.m. Mr. Shaktanshu Basu was there.
Because I have fixed according to the dates 2 p.m.
I can understand, Lord, but this is due to my own personal difficulty.
Mr. Banerjee, I'm not on that because in all the matters I have given specific dates.
This one was the divisional application which your lordship admitted earlier, directed notice.
I appreciate that.
To be hard on the issue of interim orders.
Mr. Banerjee, till the end of June, I've fixed dates at 2 p.m. urgent matters. It has to be in July. It cannot be done. That is why, please, fix matters. Please, I'm requesting you. Someone has to be ready.
Yes, yes. I mean,
someone has to be ready because I'm fixing dates because we have seen the number of mentionings.
Yes, yes.
Considering that, I'm fixing dates. That is not there too. It's difficult to accommodate on another day because the next day also there are some fixed matters. Every day you will find that there are fixed matters. It's difficult to accommodate. Considering that, believe it or not, I'm spending 1.5 hours for this.
Then this is not.
In the last Wednesday, I left the court at 8:30. If you ask all the mentioning slips, my endorsement is there. All the mentioning slips. So it's difficult, Mr. Banerjee, please. In
Can I ask
matters, someone has to be ready.
Lord, at the risk of being reprimanded, can I ask for a date in July?
Please mention in July thereafter because June it's not possible. Yes. Call the list.
Appearing for the petitioner.
Yes.
Lordship, kindly release this matter. I think your Lordship has some personal difficulty. This is this Barwipur matter, Lordship.
What is the difficulty? You have inquired, I have difficulty.
Lordship.
Or you are saying...
No, Lordship. On the last occasion, Mr. Oshiborn Raut, he appeared, he confirmed that.
Since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the papers be placed before the Honorable Chief Justice for necessary orders. Yes, next. Why the mobile number of the learned advocate has been mentioned?
No, Lordship.
Mobile number কেন থাকবে এখানে?
This is for hearing. Short matter, I'm telling you. My sister-in-law.
Short matter, Mr. Banerjee is opposing.
No, no. He will not be after my submission. He will not be called for hearing.
Yes.
But my learned friend, my sister-in-law filed a suit for eviction.
Mr. Banerjee is your sister-in-law.
Yes.
If she filed
a suit for eviction on revocation of license, I filed a suit for partition, saying that this is a joint property. Now, in the eviction suit, I also filed a written statement claiming the same thing. This is a joint property.
So according to it, those suits have to be heard analogously.
Yes, but the problem is there. But analogously, because the question is same in both the suits. If I am the co-owner,
Stages
different.
Stages are different.
Yes, that Mr. Banerjee pointed out last occasion, and I took your last time to take instruction. I find that there is 2 points. One is interlocutory application is pending, and second,
in whose suit? His suit.
In my partition suit.
In the partition suit,
interlocutory application is pending.
What is the interlocutory application?
30 parties, 30 defendants.
30
defendants.
No, what is the interlocutory application?
Injunction application. Injunction application.
Injunction application.
Where an order of status quo was passed, restraining the parties from changing nature, character, and position. That is the injunction application. And all the parties have not been appearing. I find on inquiry from my learned.
But Mr. Shah, if your suit is not
been
ready,
completed,
then
that
cannot be hard analogously. That's the difficulty.
This is the position.
And I think there are some decisions which says eviction suit should not be stayed. That should
No,
proceed.
because there is an order of injunction is also there in partition suit.
Yes, that is a
It's also
different
there.
thing altogether.
And both the suits.
What has been done? No. What is the impugned order?
Impugned order, the wrong application is state for stay of partition suit, stay of eviction suit.
That has been rejected.
Against that matter, I have come. I submitted before the court that in the facts of this case, both the should be hard analogous. But at that point of time, I was not aware that all the defendants have not been served as yet. That was not my knowledge. My learned friend the last occasion pointed out, and I inquired that this is correct.
So I am affirming this order then.
No, your lordship will record my
Cross-examination is going on. In my eviction suit, cross-examination.
your lordship will record my submission and then
Yes, because nothing will happen, Mr. Shah, if it is a suit for partition. So I think this eviction is only with regard to a portion of the property.
because
So
if I am a co-owner,
Yes,
if in this suit it has to be
you
decided.
can get another section, Mr. Shah. The if you are claiming to be a co-sharer in respect of the suit property. So if you are evicted from that portion, you will be getting another portion provided you can prove.
Firstly, he has to say this is not. I am not a co-owner. If I am a co-owner, I cannot be a licensee. That has to be decided in the eviction suit whether I am a co-owner or not.
That will be decided. If
This
that
is my
is decided, you are protected.
That is
Even
my
assuming that he gets a decree as a licensee on that, even then your shares cannot be taken away. Partition suit, you can get
if I am
another
a co-owner, then I cannot be a licensee. This is my submission.
Yes.
That has to be
So that
decided
will
in
be
this suit.
decided. That will be decided
That will be decided in the suit.
in the suit.
In this eviction suit, that
Yes,
will be
Mr.
decided.
Banerjee, what do you say?
I think could be said in terms of your
Please use the mic.
observation, because in 1992, that there was a recital in the deed, 1992 deed, and he is a son. His client is a son of my father. There was a recital that there was a oral partition.
Mr. Banerjee, considering the relationship between you, why are you not resolving this
Yeah,
dispute?
the only question is if I could be able to prove he is a licensee, I will get a degree. And I sanctioned a plan, I obtained a sanction plan, then I raised construction after the property was gifted.
All right.
Gifted, and then, my lord, I gave a ground floor the license to the defendant. That was a, my lord, undivided, that was a bare land. And, my lord, this is your lordship for the purpose of passing judgment. Your lordship will be in 2 cases that this is the certified copy. What is the position of the partition?
That Mr. Banerjee, Mr. Shah is admitting.
Yes, accepted.
Last day, I
Lordship sees.
have knowledge of
For
this.
the purpose
So
of
your
lordship
your suit, in the eviction suit, it's at the stage of evidence.
a stage of evidence, he is cross-examining.
Stage of evidence of the DW.
No, a stage the evidence of PW1 and he is cross-examining. My witness.
PW1.
PW1.
So eviction suit.
He is at the stage of cross-examination by defense.
Not of PW1.
Yes.
That is the stage of the eviction suit. And in that only both your clients are parties,
other party.
no other party. And partition suit, there are other parties as well.
So many parties.
Whether the suit property is same or suit property is a portion of that property. It has to be a portion of that property. Have you checked where is the
Portion of the in partition suit, entire property was there.
Yes, so eviction suit is
a
only
portion of it.
yes,
Eviction
that
suit
has to
mine,
be.
only mine property.
Yes, so that
is
has to be
covered by a
as
gift.
portion of that.
Covered by
So the
gift.
suit property is also not same.
Yes.
No, this eviction suit relates to the property that is also included in the partition suit.
No,
That
no.
is a portion of
That
that is
should
a
be.
portion of that. So the entire suit property is also not the same.
That
Cannot be the same.
Cannot be the same.
And partition suit service is yet to be effected upon all.
Yes.
So it's
And
not
your-
ready. It's not ready.
And super injunctions as against the other defendants.
Other interrogatory
did
applications
not take any steps. Super injunction, the so-called was issued, and that requisites were not put in, and for which they could not be able to appear.
What are the numbers of the suits? Eviction suit is numbered as 362 of 2022.
Eviction 362 of 2022.
That is the eviction suit.
No, eviction suit is 1212 of 2021.
Eviction suit is
1212 of 2021.
where do I get 1212?
Yes.
1212 of 2021. And partition suit is
362 of 2022.
So that is a subsequent suit.
Subsequent suit. After getting the summons,
After filing
I
written
filed the
statement, they
partition
filed.
suit, and then I
filed
filed
with a mala fide motive, my lord, to file a suit for partition. In order to prevent, to proceed with the execution.
Ashun.
Lordship, on behalf of opposite
I
party,
appear on behalf of
my
Deputy
learned
Commissioner.
senior is engaged in court number 15. So I am praying for kindly take up this matter at
Who's your
2 p.m.
senior?
Santanu Chatterjee and Anirban Mitra.
Yes,
We have already requested the petitioner. So,
pass over next.
My application. The second appeal was filed in this court. There was a defect in the decree. Milord, it was not rectified. Thereafter, Justice Shampa Sarkar Milord imposed cost of rupees 1 lakh.
When did you last take information about this fact, Mr. Ghosh? I'm asking you.
Milord, I had taken information.
Decree has been rectified. Records have been.
Yes, decree. I have filed also. Milord.
What have you filed?
I have filed for destruction. Everything done as per your.
Reconstruction?
Yes.
For what?
Formula.
Records are available, Mr. Ghosh. Take it from me.
Milord, this was not there. The learned court said it was not there. Milord, I have filed a reconstruction.
Now records have been pressed. Records are lying before the learned trial judge.
Lordship,
And perhaps in the meantime, the defects have also been removed.
We'll proceed, Milord. No difficulty, Milord. We'll proceed with that.
But I'm keeping it at 2 p.m. That report will be coming. It has not
Lordship
yet
has
reached.
done that. And I have also filed a section 24.
That is
I
a
have filed a
different.
section 24
That
for
is a
transfer to some
that is
other
a
court.
different thing altogether. That was the only your grievance.
Yes.
Reconstruction
Yes, proceed. I have
records are not traceable,
Yes.
for which rectification could not have been
I have
done.
filed a section-
Your application for reconstruction was not taken up. Now the records have arrived before the correct court. Perhaps in the meantime, rectification has also been done. Everything
And
resolved.
it says that court is not sitting because of boycott. I have filed a section.
That is, Mr. Ghosh, I will look into that, but please come at for a subsequent data. Subsequent data report asks.
Yes. And
That's
Milord,
it. I'm
I have
keeping it
filed a
at.
section.
Please come at 2
But
p.m.
the Honorable Milord, the other coordinate bench says his Lordship is in session of the matter. He has released it for placing it before your Lordship, the section 24. Because that court, no one is appearing. So if you see, Milord, this
Section 24 has been released.
released for taking up Milord, I have paid for assignment before.
My lord, if the defect is removed, then it will become infructuous as it.
No. He says there is section 24. He may have a say. He says that court there is boycott. That submission, Mr. Ghosh, is right.
This is implemented, Milord.
There is a boycott
Yes,
which is
there was
there
some-
so far as that court is concerned,
I'll go to some
and
of
perhaps not only that court, for last week for the entire court.
it, Milord. My
So
junior-
for section 24, if it can be expedited, that I will consider.
Yes,
That I will consider. Please come at 2 p.m.
I'll do that, definitely. I'm grateful, Milord, yesterday for giving me time, Milord, because of my family problem.
This could have been done much earlier, Mr. Ghosh.
If they come to me, I'll advise, Milord. If they don't come to me, how do I advise? I was not there, Milord, as standing counsel, Milord, in that point of time. And I have
Lord,
also
my
advised.
client is almost dead, my lord. 20 years, he's not.
So now it is almost
Oh,
done.
okay, Milord. We'll proceed. We'll get this.
So I'm keeping it at 2 p.m. Additional.
I have to go for the second appeal, Milord. I have secured the entire claim.
Yes, do that in the second appeal.
Give me 2 weeks because I have secured the entire.
And section 24, when it was released.
Yesterday. Yesterday released. I have asked for assignment before your Lordship. Because the court was of the view I was not there because of my personal difficulty.
All right, let me see what can be done in this
Section
matter
24.
so that.
There are 2 courts Lordship has heard rightly not functioning. Because they feel, Milord, the judges.
Mr. Ghosh, these records went to another district.
Yes, that I am told, Milord. I have a matter there, Milord. I am going and arguing it.
So that was brought, everything done, rectification also done. That's the latest news yesterday. The records are coming.
If that is there, I have also, Milord, complied with my part.
You can ask your Mr. Ghosh, you can do one thing. You can ask your counterpart there to take instructions so that you will also get instructions. You can also ask your counterpart there. Please come at 2 p.m. at 2 p.m. করে রাখুন.
Grateful.
2 p.m. কি ওটা একটা কাজ করুন. একটা 10 Yes.
On 14th May, my lord passed an order to asking the report from district judge, my lord, for tracing of the record.
Seven working days. 18th. Sir, I'm keeping it in the next week because the given direction within a 7 days to give instructions, you can see the report. Ashun. The learned district judge
But in this matter, I am appealing for the petitioner. Not on the last occasion, my lord was pleased to call for a report from the learned fourth bench presidency Malls Causes Court at Calcutta as to whether the defects have been removed in terms of the order passed by the learned lower appellate court and whether it has been sent back to the lower appellate court.
এই অর্ডারটা কমিউনিকেট করেনি
Lord, item number 7, I beg to appear, my lord, on behalf of the petitioner, my lord. In this matter, my lord, your lordship was pleased to direct me, my lord, to serve, my lord, copy upon, my lord, the learned advocate for the state as well as,
What
my
is
lord,
this
came.
matter?
My lord, this is, my lord, only, my lord,
For expeditious
my
disposal.
lord, I tell your lordship, my lord, this is not a simplicity of prayer for expeditious. Your lordship was pleased
You are
to look into.
complicating that.
Yes.
No, my lord,
It
lordship,
is simplicity, but you are complicating
lordship,
that.
kindly see the nature of the order impugn. Your lordship, in the earlier occasion, my
You
lord,
said in order to delay in disposing of the application, I am directing the withdrawal application to be disposed of
Yes, my
expeditiously.
lord. To
That is
that
the
extent, my lord, I will not.
lordship,
That is the prayer also.
Yes, that is the
lordship,
prayer.
kindly
You have
see.
not challenged any order.
No, no, my lord, I am not challenging. Lordship, kindly see. My lord, the court is, my lord, adjourning the matter for what reason?
My lord,
For clarification regarding assignee and assigner. When, my lord, the government has deposited the amount in my name, my lord, court is, my lord, seeking clarification.
well, these are, my lord, I believe, certified copy of the order, so it cannot be designated. Lordship may have a kind look at the order.
No, why? What clarification is necessary?
Yes, my lord, 10th of October 2023 onwards.
10th of July.
My lord, 10th of October 2023 onwards, this petitioner files adjournment petition on the ground. They have filed adjournment petition on a repeated basis.
My
lord,
I am not aggrieved with,
That
my
will
lord,
be there.
lordship,
But
kindly
why
see.
on repeated occasions, it is being fixed for clarification regarding assignee and assigner.
The 10th of July 2023. Lordship, kindly see the order.
12th of March, it has been fixed on 22nd of May. What happened on 22nd of May?
22nd of May, my lord, the PO was busy with NDPS case.
What
so,
is
my
the
lord,
next date fixed?
next date fixed is, my lord, on 25th of August.
25th of August. I'm directing on that day to decide this.
Lordship.
5th of August, matter will be, my lord. My lord.
Yes.
I do appear for the defendant petitioner
Yes.
in this two matters.
Yes.
Now, in the first revisional application, that's a 2024 revisional application.
2024, yes.
I have challenged an order where the learned trial court, while deciding an application under 151 of the CPC, that was an application for police help, has directed me to hand over keys of the terrace and the.
What is the order impugned? 24th of September 2024.
24th of September 20.
Give me a minute. Suit.
I am the defendant number 1.
Yes.
I am the person who is opposing this suit.
Yes, Mr. Doctor.
Now, why I have come up in revision.
Yes.
Suit has been filed by the plaintiff against the defendant number 1, that is my client, another defendant, seeking partition of 2 suit properties, A and B. Simultaneously with the filing of the suit, an injunction application was filed, wherein as order of status quo was granted with regard to the nature, character, and position of the property. Thereafter, immediately, once summons were served upon me, I filed an application under Order 39, Rule 7 for appointment of an advocate commissioner to make an inspection of the property to ascertain who is in possession of which part or portion of the property. My learned friend's client, that's a plaintiff, they filed an application under Section 151 for police help, alleging that after the order was passed, injunction status quo order was passed, I have put padlocks in the terrace and in the garage of the, giving a projection to the learned trial court that the plaintiff was in possession of the terrace and the garage, and after the order of status quo, I have put a padlock. What is the plain case? My lord will kindly see.
Yes.
Whether the plaintiff at the time of institution of the suit stated that he was in possession of that terrace or the garage or not. Kindly come to the plaint.
Yes.
The plaint starts at page number
first annexure of the revisional application.
Yes, Mr. Doctor, before first proceeding.
That's admission.
No, I'm not also on the admission. I'm asking you, have you put a padlock on the terrace?
That is in my possession.
No, I'm asking you. Have you put a padlock on the terrace? Yes or no?
Not. It was always in my possession.
Mr. Dotto, I'm not on possession. I'm asking you whether you have put a padlock
Yes,
on that.
I have.
So this is an, don't say it's submission of the learned advocate. So it has to be the submission of the, have you taken instructions from the client and making this?
It was in my possession. Terrace.
I'm not asking you it was in your possession or his possession. I've only asked you to say whether you have put a padlock on the terrace.
Yes, it's mine. Yes.
So this is upon instructions?
Yes. Kindly see paragraph number 7.
Let me first record that. You are the defendant number 1.
Defendant number 1.
And in the garage you have put a padlock?
Yes. My possession, my mine.
I'm only asking you the padlock. Don't go to the issue of possession.
No.
Yes.
Kindly come to page 15, para 7. That's a plaint.
Yes.
That the A schedule is the residential house.
15 paragraph 7. Yes.
That the A schedule is the residential. Your Lordship got it? The plaintiff is residing in the ground floor. The defendant number 2 is residing in the first floor. That's me.
Yes.
The defendant number 2 is married and she is residing at her husband's house near the A schedule suit property. After the death of the mother of the defendant number 1 started to create several disturbance in Ejmali possession, and very recently defendant number 1 without the permission of the plaintiff installed CCTV within the A schedule suit property with a view to create pressure upon the plaintiff, as the defendant number 1 is causing several problems in the Ejmali possession of the suit property. In the meantime, defendant number 1 has put padlock in different portions, and when the plaintiff removed the same, then the defendant number 1 filed criminal case with false allegation. So it is the plain case that the defendant number 1 is in possession of the first floor and the plaintiff is in possession of the ground floor. Padlocks were there of my kind, and the defendant number plaintiff has no possession with regard to the terrace or to the garage. Nothing said that that the plaintiff was in possession. Now, when this order of status quo was passed, kindly see the order of status quo. 32.
Yes. Where is your written statement or your objection to the injunction application?
That's page 27.
Page 27.
And the order of status quo is page 32. Plaintiff and defendant. 32.
Page 32.
32, the order of status quo. Last push. Page number, first page. 32.
Yes.
The plaintiff and the defendant are directed to maintain status quo with respect to their respective possession, nature and character of the scheduled suit property as on date till the disposal of the suit. Whoever is in possession of whatever possession will remain in possession. Nothing said in the plaint by the plaintiff that the plaintiff is in possession of the terrace and the garage. I am in possession. So the order says that the defendant number 1 will stay in possession of whatever possession he has.
What is your case in the written objection?
It's
Written-
not been annexed.
Sir, I have
Not
not.
been annexed. Not
No, 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 written objection has been annexed.
regarding police help, my lord.
Page 27?
This is the injunction application. My
No,
lord,
no,
this
page 27 is the written objection.
is the injunction regarding
Injunction. That's
my lord, this is the
Written objection on behalf of the defendant number one against the injunction. Against the,
injunction application. I am giving the objection regarding police help, my lord. They have not.
I'm not on police help. I'm on the injunction objection. Yes, what is your case in the injunction objection?
I have denied all the contentions of
And
the
specific contention with regard to possession?
kindly come to page 27.
Yes.
Said that the right title and interest originally
Show me with regard to your exclusive possession, which portion you have stated.
kindly see para 16.
Para
16 I have said
1-6.
yes.
Yes.
I have said admitted the shares,
Yes.
specified the share. This is the share of the
Yes.
which
Possession, exclusive possession.
nothing about possession.
Nothing with regard to possession.
It's denied.
Yes.
Now, your lordship will come to the what is the case which the plaintiff has made out in the 151 application for police help. 35.
Page
35, Annexure D.
Yes.
1, 2, 3. Para 1 is of the suit, 2 is the order. Now, para 4 said out of the suit property, the A schedule property is a residential house, and the plaintiff and the defendant number 1 are residing there. The plaintiff is residing in the ground floor, and the defendant number 1 is residing in the first floor. Although the A schedule property, that is a residential house, is the joint property of the parties, but the defendant number 1, after passing of the order of temporary injunction, most illegally put padlocks on the roof, garage in the ground floor. The plaintiff requested the defendant number 1 to open the same, but the defendant did not pay any heed, but he refused. The plaintiff went to the local police station and lodged a GT. No, wait, right now. Now, what is the order? Now, simultaneously with
only one thing, you have put the padlock you have admitted. Have you given a one key to duplicate key to the plaintiff?
with regard to the garage space, there is a duplicate already with the plaintiff.
Is already with the
Yes,
plaintiff.
but with
And with
regard to the
terrace?
terrace, I am in exclusive possession of the terrace.
All right. So with regard to the garage, according to you, the plaintiff is having a duplicate key.
We have a duplicate key. But then with regard to the terrace, that is in my exclusive possession. And kindly come to my application under order.
With regard to the garage, if you don't have any objection, if both of you have two keys.
We have two keys.
Don't have any objection. Yes.
34, because since I am in possession, because the order of status quo does not specify who is in possession or what. It's a blind order says status quo, who does not say whether they are in possession or I am in possession. So I went to the court and said that please appoint a commissioner, go to the property, who will take a note so that this order of status quo becomes confirm, more firm.
Commissioner Mr. Dotto appointed under Order 39 Rule 7 can decide the issue of possession.
Kindly see page 34.
I'm asking you, can decide the issue of possession.
Can make an inventory.
I'm asking you, possession can be decided by the commissioner appointed.
Can take a note of who is in possession. Can't decide title. Can't
possession. I've not said up with regard to the title. I'm asking you, can a commissioner appointed under Order 39 Rule 7 decide the issue of possession?
No, can't decide of possession, but take a note who is in possession.
That means deciding. That means in a way deciding.
If there is a dispute, suppose A says
so the commissioner will decide that. If there is a dispute whether A or B is in possession, commissioner will decide that. Go to the local and say yes, A is in possession. So
My respectful submission is no. If there is a dispute with regard to this place,
thank you.
A says,
Yes,
A,
now you can proceed.
A says I am in possession, B says
All
the
right.
commissioner will record it and place it before the
Thank
court.
you. Now you can proceed.
Kindly come to page 34.
Yes.
Point 2. To go to one is to go to the suit locality and identify the suit with the help of the plaintiff.
You are not challenging this order.
No, why I am placing it, I will place. Number 2, to note the present position of the suit property. And 3, to note the illegal act of the plaintiff and the present position of the boundary.
That is, Mr. Dotto, this application was filed in aid of an application for violation of an injunction. This local inspection.
No,
was
I filed this application.
in aid of an allegation of violation of an order of injunction. We are on 151. Please
counter.
restrict your submissions on 151.
Now, your lordship will kindly come to the order.
Yes.
Why I have challenged? 4 grounds. The first issue, this order, this application was filed for execution of the order of an order of status quo. Now, what was the status of the
That is not ascertained.
That is not ascertained.
So that could not have been implemented according to you.
This is my first issue.
Yes.
And the plaintiff categorically states and admits in the plain that the plaintiff is in possession of the ground floor and the defendant number 1 is in the possession of the first floor. Nothing said about the garage and the roof, who is in possession. So, my first question to myself, so how did the learned trial court come to the conclusion that the plaintiff is in possession, was in possession of the ground floor and of the garage and the terrace? Without ascertaining.
This is your submission.
First.
Anything more?
Second. Now, if today this order is allowed to stand, that would amount to modification of the order, of the status
quo order.
Third issue. Today, if this order is allowed to sustain, the learned trial court, while proceeding to pass the order, it says that this is a suit for partition. Every party has a right in every part and inch of the property. So he should be allowed to gain an access to the terrace and the garage. This is amounts to final adjudication of the suit itself.
Yes. Anything more?
This is the 3 and the 4th. If this order is allowed to stand, my lord has seen in the first part of the order, the learned trial court has allowed my application order 39 rule 7 for the advocate commissioner to go and inspect the property. Now today the advocate commissioner, if this order is allowed to stand, then by the time the learned advocate commissioner goes, the position
will change.
Yes.
What he will note.
Twice that part becomes.
What he will note then.
Yes.
Anything more?
No, that is fine. This order cannot sustain. This order should.
Right. What is the other civil division application?
That application, because I filed this application, my lord will see in 2024. Once I filed, it was not taken up. It was running in the list, but it was not taken up. So I went before the learned trial court saying that this matter is sub judice. So kindly stay off your hands. Give me some time. By the time my lords will take.
Stay off the order of implementation.
Yes, stay off the order. Don't proceed with the suit. Adjournment petition on that ground. Learned trial court decline its matter pending, so I will not wait, decline. So I don't have an alternative. I file a revisional application.
So basically, this is the main matter.
Yes.
Is anything
first, it is the main matter.
Yes, Mr. Das.
In the plain, my lord, I specifically stated I have removed the same thereafter padlock. I have removed in the page 16. It is specific my case that plaintiff removed the same, then defendant filed.
Where is that?
My lord, page 16, page 4 of the plaint, page 16. In the meantime, the defendant number put padlock in different portion. Yes. When the plaintiff removed the same, the defendant filed criminal cases. My lord, admittedly, 2 or 3 criminal cases contesting between the parties. My lord, thereafter, my lord, he after passing the order of status quo, he put a padlock. That's why I filed, my lord, general diary before the concerned police station, my lord.
Yes.
After, my lord, kindly see in page 36, I specifically stated paragraph 4. Dependent 6 lines up from the top. The defendant number 1, after passing the order temporary injunction, most illegally put padlock entrance of the roof of the entrance of the roof and garage.
I could not find page.
Page 36,
Yes,
paragraph 4,
yes,
after 6 lines from the top, the defendant number 1 after passing the order,
yes, yes, I've got that. Yes,
temporary injunction, most illegally put the padlock in entrance of the roof, garage in the ground floor. The plaintiff requested the defendant number 1 to open the same, but he did not pay any heed. He refused. The plaintiff went to local police station, lost a general ID, such as request to stay. Thereafter, what my prayer, page 37, my lord, in this, before the trial court, and open the padlock in the entrance of the roof and garage in the ground floor. I have specifically prayed for, my lord, in kindly come to the impugned order. He admitted that. That's why, my lord, he present. My specific instruction is he was petitioner was present, and my lord, his learned advocate, my lord, is a relative of this petitioner, my lord. My lord, that's why the admission is made that learned advocate of the defendant admitted the fact the padlock of the door of the entrance and garage of the ground floor has stated that the key of the garage has been also provided to the plaintiff. So no order should be passed regard the same. There, my lord, he did not file any modification of the order. No ground has been taken in this revisional application also. That's why, my lord, the order has been passed.
yes.
That has been done after passing the order of the injunction order, my lord. Court note it. And my lord, regarding order 39 rule 7, it has been filed after my application, my lord, in September.
Which application?
Order 39 rule 7, he is pressing on page 33.
Yes,
This has been filed on 2nd September. My application is 13th August 2024.
Very next day.
After my application, page 35, they have
your application was on 13th of August. Where do I find that?
yes, my lord, in page 33, that has been filed after my application.
When have you filed this 151? Where do I find that?
Their application, my lord.
No, your application,
Your application is, my lord, in the court.
Yes, 13th of August.
Court's order, it has been noted.
13th of August.
Yes.
And their application,
Their application, my lord, much
2nd of
after.
September.
Yes.
Yes.
That's
Anything more? This application under Article 227 of the Constitution
Only this is.
See, who is appearing for the,
Appearing.
I-
This is
I
with
have been
respect to,
today, my
no,
lord.
this is
Why
with
is this
respect to
matter?
the custody matter, your lordship recalls.
No, no.
Today, the date was fixed.
keeping it tomorrow?
I don't have any problem. The problem is, Lord, under the Lord.
All right, come up. I'm coming after 5 minutes.
With respect to item number 3, Lord, today, therein I do not stand in the only difficulty is tomorrow as to be mentioned.
It is appearing under what head?
As
Item number 3 is for orders.
For
It will
orders.
appear under the same heading.
same head. Wait.
Item number 3.
Item number 3.
You are for the
Relates to
opposite
your
party.
that, custody
Item
matter.
number 3 টাতে লিখে দিন একটা অর্ডার রেকর্ড করে নিন।
Yes. The plaintiff is the petitioner before your lordship.
But I am for the opposite parties.
By the order impugned, my lord, my application for implementation of police help is being rejected. May I, my lord? What is, my lord, the matter, my lord? It is the case of the plaintiff that the
You are appealing for the opposite party.
that the B schedule property is exclusively gifted by my father. The C schedule property, life interest is being given to the defendant number 1.
He is the defendant number 1.
Defendant number 1 and defendant number 2.
The son. Life interest is being given. So he is not the absolute owner in respect of the she. So, my lord, by virtue of that, my lord, settlement or my lord, that, my lord, he cannot have any exclusive right to make any construction or let out garages in the vacant portion of the she schedule property. That is, my lord, my plaintiff case. Apropos injunction has been prayed for. What injunction has been granted? May I take your lordship to page 41? Because the prima facie, the court found, yes, the she schedule, he do not have any exclusive right to make construction.
Page 41.
41, my lord, may I read the operating portion? Defendants are restrained to lend the temporary structure for the purpose of car parking to the outsiders on rent till disposal of the suit. However, there is no order of injunction for using the said structure for his own car parking. Admittedly, he do not own any car. Admittedly. Second thing, my lord, the local inspection held and a kacha structure for parking arena is being, my lord, there that has been come to before the court, and the court restrained him from letting the car, the outsider's car, to be parked over there. That is, my lord, sum and substance.
That construction was in violation of the order of injunction.
No, my lord, that temporary structure
Was there.
was there. Local inspection held. I must be candid before your lordship.
Yes.
Page 40.
Now, what is the impugned order?
Yes, page 42 is my application under section 151 for implementation of this. Not complying with.
What is your allegation?
But I am just page 60 if your lordship wants take trouble to come.
60.
60. My lord, it is a part of, my lord, my application under section 151 complied, my lord, 65A. My lord, the electronic evidence.
Page 60.
60.
Yes.
My lord, this is the she schedule property gate. My lord,
Yes.
kindly 6 এখানে যে কোনো ছোট গাড়ি রাখার জন্য গ্যারেজ ভাড়া পাওয়া যায় যোগাযোগে, my lord, this number. This, my lord, electronic evidence I have proved with certificate I have given before the learned trial judge. My lord, subsequent picture your lordship will get, my lord, one car is there with advocate sticker. My lord, the court has dealt with this.
Advocate sticker.
No, my lord, it is not his. My lord, there is no advocate on his
Advocate
family.
sticker, yes.
My lord, kindly now takes up the order impute. My lord, the longish order, my lord, every aspect has been gone into, and may I say, my lord, the court is in my favor. My lord, the last paragraph of the order impugned, may I take your lordship without troubling, because this is the operating court.
Yes, yes.
Now the question that has come before this court for adjudication is whether the mere parking of the vehicle of the learned advocate tantamounts to violation of the order of this court or not. The answer, in my opinion, is certainly yes. So court is affirmative on my plea. If the same is coupled with rent, but in the instant case, the plaintiff did not file any document to show prima facie that the rent was paid by the learned advocate against the parking of the vehicle over the she schedule property to the defendants. Moreover, learned inspection commissioner in his inspection report had stated that the house of the learned defense counsel of the defendant is lying adjacent opposite to the house of the defendant and had also a garage. So, my lord, since I could not able to show that is this Milord parking of car is against payment of any rent, Milord, in my respectful submission, can I? Is it possible for me? This is the interse between two private party. Even the rent receipts are being issued. Can I have a hold of that receipts? But prima facie, I have able to show that there is an order of injunction, no challenge to that, and they are making advertisement that yes, this space is available for letting out car. So is that I'm
Yes.
entitled, Milord, as if to implement
I
that?
have, firstly, I must say, my lord, the learned court below
Please use the microphone.
the learned court below rightly rejected the application as preferred by the plaintiffs. My lord, if your lordship kindly come to page 41 once again,
Whose car is that?
and I am coming.
That is the only question. Please come to that straight away. Whose car is that?
My lord, the car is the owner of the car is the advocate who is defending the
Not a
defendant.
party to the suit.
He is not a party.
So how can
But
that
he
car
is
be
a-
kept there?
But he is also a relative to the parties.
Maybe,
He is not a party. But
maybe,
he is also a relative to the parties.
maybe.
And my lord, I have not hide out
Are you
any.
allowing all relatives' car to be parked there?
No, my lord. I have not hide out anything before the learned trial court. Admittedly, my car was, my lord, the learned advocate who is practicing at Siram.
Sir, please,
No, my
please
lord,
don't, please.
he is personally present here out of his own curiosity, my lord.
Sir, please, that is not the issue.
No, my lord,
Don't
I am not.
exhibit the
I am not.
That's not the thing, but the question remains, how can a car of a third party be kept?
My lord, kindly come to the order portion, my lord.
Yes,
Just last para, second last para, my lord.
yes.
On careful, my lord, I am reading, my lord.
Second last paragraph of,
The order impugned.
yes, last page.
Last page.
Yes, it starts with now the plaintiff.
Yes, yes.
Yes,
Now the plaintiff, by I am not reading from such way. I am reading from on careful
on
examination.
careful examination, yes.
It appears that one red color car with the sticker of advocate has been parked in the temporary structure or garage over the scheduled property, and the said vehicle was registered in the name of one Tapan Kumar Mukherjee, who is the defending advocate, who is but none other than the learned advocate for the defendants. Such facts has also been admitted in by him in course of hearing before the learned defender.
Can that car be kept? I'm asking you.
My lord, the matter is that
Does it not amount to violation of the order of
No,
injunction?
my lord, kindly come to the previous page of the
Yes,
order.
previous page, yes.
That the paragraph starts with the learned lawyer of the defendant.
Yes,
In course of hearing, further contended that the photograph of the car and the document filed by the plaintiff with regard to the particulars of the car belongs to him. He has admitted. He is related to the plaintiff and the defendants.
maybe, sir. They're not
No,
the
my-
party to the suit.
He's
Where
not
is
a-
the order of injunction?
Means the defendant number 2, who happens to be the grandson and also unemployed, my lord, the defendant number
Then
2 or
proceed,
the
proceed,
opposite
then
party number
proceed.
2
Then proceed.
presently driving his car against some remuneration. Defendant number 2 had parked the car in scheduled property only for the cleaning purpose.
So now the car is not there.
No.
So only on that date, I will record your submission only on that date for cleaning purpose you have kept. So
My
I will
lord,
record your
my lord,
submission, end of the matter. I'm
Number
accepting
2
that.
The opposite party number 2 work as an assistant or as a driver to the learned advocate.
That does not entitle you to keep that car there.
And they are both of them have both of their house are just opposite. to
Maybe. Sir, please, if you allow.
And if your lordship kindly come to the commission report, your lordship also found that the learned advocate who is defending the opposite parties before the learned trial court, he has his own garage.
Then why that is being kept here?
My lord, for the cleaning purpose, only for.
I will record your submission. That was for the cleaning
Only
purpose.
for cleaning
And that will
purpose.
not be kept any further.
Sir, I have
Please don't
stated
keep
in
it
this
for cleaning purpose also.
Only for cleaning purpose.
On that date,
whenever
no.
he moves
Not
the
on any
car.
other day. Please don't further keep it for cleaning purpose also.
My lord, if your lordship kindly come to the earlier order,
Let kindly come to page 41.
Yes,
The injunction order, my lord.
yes.
The learned court directed, and I have obeyed the line by line of the direction. What it has been directed? Defendants are restrained to lend.
That
temporary
means on consideration. According to you, there is no monetary consideration.
There is no monetary consideration.
Sir, there are decisions on this. Galore of
There
this
is no
Supreme Court
monetary
also.
But
Mr.
there is
Mukherjee has not brought those judgments. I was expecting those judgments to be brought. Those have not been brought. There are a line of decisions on subletting.
It is
There
not
are a
about
line of
sublet-
decisions on subletting. The initial view was that
my humble
that payment
submission is this.
consideration is to be proved. Now,
So,
the
my lord,
view
my-
is that if the possession of a third party is proved, that amounts to subletting. There's no requirement to prove. I will apply that proposition. If you are on that, I can apply that proposition here. Yes, anything more, sir?
Yes, sir. Yes, sir.
My lord, kindly
Yes,
allow
will I
him
be
to
allowed?
Sir, you are
I'm
representing.
senior of him, sir.
Sir, you have not said that.
My name is implicated in this case, sir.
All right.
I am Mr. Tapur.
Yes, you make your submission. You make your submission.
He has come.
Tell me. Both the parties of the lower court suit are my nephew as well as grandson. The grandson is an unemployed one. He drives my car every day. আমাকে কোর্টে নিয়ে যায়, কোর্ট থেকে বাড়ি আসে, এইভাবে চলছে।
Sir, your house is situated adjacent to the suit property.
Adjacent.
There is a garage. There is a garage in your suit property.
Let me allow, sir. For the time being, when it is required, my driver cleans the car. After getting it from my garage, just opposite, local garage, ওখানে পাইপ আছে নিয়ে ওয়াশ করে আবার গাড়ি বাইরে করে নিয়ে করে চলে যায়। It is the practice, sir. Commission, when the commission was held, no car was found by the learned commissioner. Your Honor can find it from the commission. Apart from that, the commissioner has specifically stated that the learned advocate's house is a southern side, just opposite to the defendant's and plaintiff's house. So, sir, and he also stated that he has own garage. Sir, Your Honor is expecting that rent is taken by the dependent from the no, sir. No, sir. Because of the fact there is no relation of taking rent for use purpose, sir. Sir, for use for the car parking to the outsider. First, there are 3 points in the order sheet.
Yes.
Lent.
Yes.
Your Honor is saying that why lent can be suppressed.
Yes.
Is the between understanding in between the tenant and landlord. But there is no relation of tenant and landlord. It has not been proved before at the time of hearing of the petition that the learned advocate is the tenant under the dependent number 2 as landlord, but the son of landlord. It has not been proved. Second point is outsider. Sir, who is outsider, sir? Who is outsider, sir? Whenever it has been mentioned that I am the related person, the relation of grandson and nephew has been stated. So, is there any questions that the outsider? Am I the outsider, sir?
Yes.
Third point, sir. Rent receipt. Rent receipt. Rent receipt. For the sake of argument, যদি লেখা থাকতো যে rent receipt or otherwise, there was a chance of licensing. License was given for temporary purpose. So Your Honor cannot find it যে ওনাকে এ করেছে যে একদম he was not allowed to clean his car. So I think that even said, yes, I forgot to. So what is the specific section? He has stated gross violation of the injunction, but he did not mention in his petition what type of violation. He did not specifically mention.
Moreover, sir, he did not did not mention in his petition that the opposite party, that the dependents is allowing the learned advocate to keep the vehicle on the civil property. Who is the owner of the civil property, sir? Civil property is situated within 200 meters from the peaceful property. Total property belongs to civil property. Peaceful property belongs to particularly plaintiff, that is petitioner. Civil property belongs to the defendant. So, sir, there is no order that the learned advocate has kept his car against the rain. How your owner will fight? And one picture has been given. But it cannot be proved that under what position the said vehicle is standing. Under what vehicle? Until unless it has been proved on dock at the stage of trial of the suit. So what is the wrong, sir, of the London Lower Court? What is the London Lower Court? I have been compelled to express myself before your honor. I have been compelled. I am not outsider. আমি মনে গেলে 10 দিন অসুখ পালন করতে হবে আমার ভাইপোকে আমার ভাইপোর ছেলেকে ওর বাবা মারা গেছে আমি 10 দিন অসুখ পালন করেছি স্যার
Anything more, sir?
So sir, so my question is this, sir. The order is correct. Parking, sir. What do you mean by parking, sir? Parking. কোনো গাড়িকে কোথাও লাগলে সেটাকে বলে parking. Whenever I have personal garage on the floor of my 3-story building, there is no question of parking my car on the CC land. No question, sir. That's why it has not been specifically stated in the lower court suit, in the lower court petition, and also 151 petition, sir. So how it can be determined without going to the trial stage that photo has proved that the car has been permanently kept under the temporary structure. So my humble submission, sir, the petition under 151 filed by the petitioner plaintiff in the lower court, and that has been correctly rejected. And I pray also before your honor, this petition is likely to be, sir, rejected.
Is
Likely to be rejected by your honor.
yes, thank you.
By your honor. Wonderful.
Ashun.
A suit for declaration and injunction. I am the plaintiff. I took out an application under Order 6, Rule 17 for explanation of the foundational statement in my plaint.
Or explanation of
The foundational statement.
what is the foundational statement you want
That
to?
I have been in possession of the suit property since 1976, pursuant to a written heba, preceding by a oral heba and delivery of possession. And I have been in
What was the
uninterrupted.
relief claimed in the suit?
The suit for declaration manner may kindly turns to the
You have
plaintiff.
claimed title in respect of the property.
Yes, I have claimed
By way of amendment, what did you want to do? Claiming adverse possession.
the adverse possession.
So what is the basic principle for adverse possession? You have to accept the title. When you are disputing the title, you have claimed your title. Can you claim adverse possession?
In my respectful submission, my lord, if my lord may kindly turns to page.
Are you admitting the title of the plaintiff?
But that
of the
title,
defendant?
that title has been sought to be denied by the trial court on ground.
For claiming adverse possession, the basic principle is that you have to admit his title and say by virtue of passage of time that title extinguished and you have acquired title. But the case made out in the plaint is that you have paid for declaration of title. So when you have accepted that you are the owner, how can you claim you are not accepting? Mr. Basu, show me that you have accepted his ownership.
Kindly see, my lord. Page 3, para 3 of the plaint.
When Mr. Basu, the suit was rightly dismissed. You did not.
Only it was dismissed only on
admitting the title of the defendant. Your suit was rightly dismissed. Appeal can be disposed of from here.
No, may I just indicate your lordship, my lord? There was a oral heba.
Mr. Basu, when you are claiming oral
heba,
you are claiming title by virtue of a deed. So you are disputing the title of the erstwhile owner.
Absolutely.
So when you are disputing the title, we are claiming your title by virtue of a deed. Can you at the same time claim adverse possession? Because the basic principle is that you have to admit that title and say by passage of
continuous possession. Yes, yes.
Thank you, sir. Thank you. Ashok, this application under Article 2. Yes, Mr. Bose.
My lord, this is directed against an order passed by the West Bengal State Micro and Small Enterprises Litigation Council. There is a dispute between my clients, my lord, and the respondent number 8.
There is no caveat.
There is no caveat.
Yes.
There is no caveat. I must tell you, lordship. But the respondent number 8, my lord, referred the disputes to the facilitation council. But as on the date of reference, he did not have the adequate license by which, or registration certificate, on the basis of which he could have approached the council. I, my lord, took out an application under section 16 of the Arbitration and Conciliation Act, saying that the facilitation council does not have the jurisdiction to even enter into the case because he didn't have the requisite certification. My application has been dismissed. Of course, I took a whole lot of other points, but the principal point which goes to the root of the matter and which makes it an exceptional case in the facts and circumstances of this particular reference is that, my lord, the council lacked the jurisdiction. The council records in its order that certification was obtained on 7th of March 2020. Whereas, my lord, the documents show that
the contract was
entered
on 25th February
2022. 2021. So, my lord,
So registration was prior to the
no, post. And your lordship knows, my lord, the Supreme Court has repeatedly said that unless the registration is there as on the date of the contract, the question of assuming jurisdiction of such a council, my lord, does not arise. That is why I've come up. My lord, today, since my application has been dismissed, the arbitration will proceed. Today, the only order that I was praying is a status quo so far as the arbitration is concerned. Let them come back, let them satisfy your lordship, and then, my lord, the matter can proceed.
So, both that was the preliminary point which you have taken.
Section 16 is the only alternative open.
With regard to the jurisdiction.
Yes. Section 16 is your
So,
lordship.
instead of saying that let it proceed, if it is set aside, that goes. Otherwise,
I shall show your lordship, my lord. Then allow me, my lord, today time is short. Allow me to come back to your lordship to show your lordship the Supreme Court judgments which say unless there is a certificate as on the date
of entering
into the contract, the question of the
show me the finding.
Yes, 36.
My lord,
That it is post
36.
Page 36.
36.
Page 36.
Starts on page 35.
Yes.
But the relevant portion is on page 36, decision of the council.
They have observed.
Found, my lord has found it.
Yes.
It is found that the supply unit got their MSME registration reading Uddog registration number 73/2020 before the initiation of
This
the
is
contract.
wrong.
So it finds before the initiation of contract.
This is what he says, but this is wrong.
39, page 39.
Page 39, show it.
Page 39.
Yes. 25th February 2020.
Letter of intent.
Letter of intent is 25th February 2020.
No, where is the contract?
This is the contract. This is the letter of
No,
intent.
this is the final offer. This is not the contract. This is the offer, final offer.
Intent. Kindly see, my lord. Kindly see.
No, Mr. Bose, letter of intent is one thing. Where is the contract? When it was executed?
Page 40 to that.
Page 40, kindly come.
No, letter of intent is a document prior to execution of the contract that gives the right that
This is the contract. The supporting documents.
where is the contract? Where is the statutory contract?
Kindly read the letter. All terms are here. All the terms are here. Kindly read.
No, maybe all the terms. No formal contract was entered into.
Yes.
Where is that?
There is no document, but the documents in support there are page 41 onwards are all the documents which
Bills,
go to show the bills raised, etc. All.
No, Mr. Bose, no formal contract was executed.
This is the contract. The parties acted on the basis of this. The dispute arose. He says that there were some bills which were unpaid, and that is why he raised a claim of 2 crores or not before the
Commencement date is there.
The
And page,
commencement date is all there,
it is also prior to the date of the certificate.
and it is also, my lord, prior to the date of the
Page 40.
Page 40. The total value of the
No. This is not that. The necessary documents, registration, insurance, fitness certificate for the machines required to be, all other terms will be as per the discussions cited under further. A contract with detailed terms will be mutually signed off. Where is that?
But the work has started on the basis of the letter of intent. Otherwise, there was nothing else.
This is the date of entry.
But this letter which you are relying upon at page 39 shows states that there will be a contract entered into mutually.
Kindly just read one paragraph with me. Kindly come to page 40, the first paragraph on the top.
Yes.
The LOI is intended to set forth the basic terms around potential relationship between Megawide Construction and JD Construction.
LOI, next paragraph, is not intended to be a contract between the parties. Rather, it is intended to set forth the terms. LOI is not the final contract, Mr. Bose. Where is the final contract?
Well, the final
I think that is the reasoning of the arbitrator.
No.
Because before the initiation of the contract, show me the contract.
My lord, may I just first place the order? Then, my lord, just give me just 5 minutes. Let me first place the order. Kindly come to page 36.
Yes.
It's found that the supply unit got the MSME registration, VDA registration number 73-2020 before the initiation of the contract. The question is, where does he get this? I shall show your lordship that this finding is erroneous. But let me read the rest of the order thereafter. Members opine that the declaration of MSE status of the supplier unit before participating of the tender is not mandatory. This is wrong. I should cite Supreme Court judgment to say so. It further clarifies that MSME units have been migrated from Uddog Aadhaar to Uddog.
So according to you, before participation, this registration has to be done.
Yes.
That is the end of the matter. Show me that.
My lord.
Before participation,
Yes.
according to you, this against Supreme Court decision that before participation, this declaration of MSME status is to be there.
Nitesh. My lord, Nitesh Estates Limited versus copy now.
Shilpi Industry. There's 4 judgments.
2022 SCC Online, Supreme Court 1198. Kindly, my lord.
Yes.
Paragraph 2. It is the case on behalf of the appellant that at the time when brokerage agreement was entered into between the appellant and respondent number 2 was not registered as micro enterprise under the Micro, Small and Medium Enterprises Development Act. And therefore, the initiation of proceedings by the respondent number 2 under the Act was bad in law. On the other hand, it is the case on behalf of the respondent number 2 that subsequently, in the year 2016, respondent number 2 got the registration under the Act retrospectively with effect from 2006, and therefore the proceedings initiated by the respondent under the Act were maintainable. It is also the case on behalf of the respondent number 2 that when respondent number 2 filed proceedings before the National Company Law Tribunal, Bengaluru, the appellant agreed that let the proceedings be proceeded further. Well, kindly come to paragraph 4. Having heard learned counsel appearing on behalf of the respective parties, the question which is posed for consideration of the court is whether the proceedings initiated by the respondent number 2 under the Act would be maintainable and affirmable as at the time of entering into the brokerage agreement, respondent number 2 was not registered as a micro enterprise. The issue involved is clearly covered against.
Where is the answer of this? This is the question posed. Where is the answer to this issue?
Issue involved in this.
Kindly just allow me to read this paragraph.
Yes.
The issue involved is squarely covered against the respondents in view of the decision of this court in Shilpi Industries versus Kerala State Road Transport 2021, as well as the subsequent decision of the court in Vaishnav Enterprises versus so and so. Taking the review that for initiation of proceedings under the Act, the registration of the complainant as micro.
Yes, Mr. Bose, the factual part is, in this case, there was a brokerage agreement entered into that. So this was subsequent. So here in your case, it's a different thing. There's an LOI and there is a subsequent contract. Registration is in between. This judgment may not apply to that fact.
LOI is dated a particular date and they get the registration 2 years later. 2 years later.
When where is the contract? Where is the contract?
Parties are agreeing.
Suppose please produce the contract, because the contract, this letter shows that a contract has to be entered into. Because this decision is, agreement was entered into. In your case, there is an LOI and subsequent contract. The arbitrator arrives at the finding of fact that it was though post LOI, but
where are the reasons given by the arbitrator?
Show me the contract. Have you annexed the contract, or I can fix another date for producing the contract?
My lord, I shall take instructions. If there is a formal contract, I shall produce.
Because that letter which you have produced, this states that there will be a contract entered into.
But if I manage to prove to your lordship that the work started on the basis of the LOI, parties acted on the basis of the LOI,
Commencement.
claim is also on the basis of the LOI, bills raised on the.
Is it your case that there was no formal contract entered into between the parties?
Formality, that was just a.
Maybe.
There may be. I will take instructions. There may be.
All right.
But the point.
Please take instructions because that
law,
is.
On the basis of the law.
That may be required because this Supreme Court judgment there.
There are more Supreme Court judgments.
No, this. Yes.
There
So
are
it-
more Supreme Court judgments.
Yes.
I have all
In
of them.
this, it's an agreement which was entered into and the registration was post.
I should take instructions.
After some argument. একটা দশে যেটা ফিক্স আছে
My lord, I am mentioning one item number 29, next section 24, my lord.
Item number
29, my lord. Your lordship,
29.
the order is already there, your lordship. Matter release.
Then why
Or
did that
before the
delay?
regular,
এটা দেখে নিন তো আইটেম 21 29 টা রিলিজের অর্ডার হয়ে গেছে বলছে Yes, Mr. Bakri.
Indulgence, for indulgence.
Yes.
My lord, 32. My lord, I am opposing Mr. Mahato.
Who is proposing?
I propose Mr. Mahato. He is in difficulty, my lord.
Who is in difficulty today?
Next Wednesday at 2.
last line, you.
All right, give me a minute.
Joint prayer.
Oh, there was a direction for service. There was no direction for releasing.
The last line, go before the regular bench.
ও লিস্ট দিস ম্যাটার বিফোর দ্য রেগুলার বেঞ্চ করা আছে তো ফাইলটা কি যায়নি আবার কেন লিস্টে আসছে দেখে নিন এটা
Matter.
ইয়েস স্যার আইটেম নাম্বার 29 টা একটা 10 ফিক্সড ম্যাটার এসছে রিপোর্টটা নি
হ্যাঁ
কিন্তু তো একবার বলে দিন আসেনি
আইটেম নাম্বার 32 আইটেম নাম্বার 32 একটা অর্ডার রেকর্ড Please wait. Hello. It has not yet reached. So
When should I come? I come back at 3 o'clock?
I think it's better.
I come at 3 o'clock.
3 o'clock or just before rising. কি হলো কি খবর এসছে?
When Dear Miller,
I think
When-
come
when
at
should when should I come back?
at a fixed matter আছে।
I
come
come
at
at
4:10.
I'll be waiting here from 4:10.
You don't have to wait. You have other businesses, Mr. Ghosh. How can
Today
I?
the courts are going slow, Miller.
How can I detain you in this court?
When the courts are going slow. It's a hearing matter, Miller. Lordship knows if a hearing matter, Miller, gets in, Miller. Naturally, it takes time in all.
No, this was because I have, Mr. Ghosh, I tell you, I've got a telephonic information with regard to that. But unless I get a hard copy of that report,
Miller, I want to sort out the issue. There's a
issues have been
declaration.
sorted out.
Yes.
You be rest assured. Issues have been sorted out. Record stress.
Yes.
Most probably, the rectification has also been.
The senior most person there, Miller, told me, Miller, he is the brother.
You have you taken instructions? Have you?
Yes, I have taken instructions. She's also, Miller, taking and sending me. I say, you whatever you send, you WhatsApp me. Don't say to me orally.
No. What did she say?
Miller, she's saying records are now, Miller, can be found. Let us, Miller, see, Miller. Let me say, I don't want
Records
to.
have been found. Please ask her to take instructions.
Even it is not found, my entire record, I have made it ready.
Records have been found. Records have been found. Records have been found. I think the rectification also has been carried out.
Basu Miller nowadays have become more active.
Rectification has also been carried out.
Rectification
You have not taken that instruction.
Records have already been traced in go down in Bardhaman. Rectification part, I am personally calling.
Records have arrived before this court. It has been called for. It has now been.
Rectification I'll take that. Lordship,
please take instructions. I am keeping
she
it
must be in
4:10.
court. She received.
Item number 14, my learned friend is appearing for the petitioner, my lord.
Yes.
My lord, my lord, on put below on 12th June, it was date.
Item number
14, next matter.
So, my lord, I would like to, my lord, oppose this matter, so let their direction for serving copy and they fix a date. Bas.
Consequently, fix a date, Lordship.
And
Order.
caveat.
No
Okay,
caveat.
my lord.
Let me see whether she can cross the first hurdle. Let me see.
12 was the date in the court below. On 11th, he served me.
If your assistance is not required, prior to that anything is done. Even then you want the copy. Let me see.
My lord, item number
Let me see whether that is necessary or not.
item number 64, my lord. My lord, today was the date before the consumer forum. My lord, they are not allowing time, my lord. My lord,
Today was the date. What is the next date fixed?
my lord, that has not been fixed.
Please,
But my lord,
please take instructions.
my lord, they are not allowing us to
Yes,
time.
the boss, which matter?
Item 20. I don't know whether it will be called or.
There are some 2 p.m. fixed matters. Thereafter, it will be called.
My lord, if I'll do it. If I am not, my lord, I am the leader, Mr. Sudipto Sarkar. Now, I request if it is not called on, then can it be on 25th, my lord? If it is not called on,
Ask your advocate on record to remain present. Let me see what happens.
Yes, whatever. I will be there.
Lordship,
I won't miss the opportunity. My turn has come. My lord, no caveat.
This is the difficulty
I
because
will not
once the
miss my
turn goes,
no.
you
That's
will not
why
go.
I am afraid of that. Just in case.
Because I am trying.
I bow down to your lordship's procedure. If no one should get any precedence, I bow down to that. So I don't want to miss that turn on the ground.
Thank you.
Lordship,
Please.
may I permit to mention one matter for release, Lordship? Item a monthly in the monthly list.
Why?
Item number personal ground. Your Lordship can't hear
What
the
is the
matter.
personal ground? What is the reasoning?
My senior was instructed me that
Ask your senior to appear.
Lordship.
Give me a minute.
সিনিয়র বলে সেটাই বলা বলা উচিত হয়নি
I'm praying for leave to file this application without the certified copy.
Why? What is the urgency?
Urgency is that, my lord, in execution proceedings, my lord, my vehicle has been attached. I am neither a party to that proceeding. I am neither involved in any manner toward in that proceeding.
When the order was passed?
The order was passed on 29th of April 2020.
What were you doing for so long?
I have been communicated the order from the RTO office on 9th of June. Thereafter, I filed an application under Order 21, Rule 58 before the execution court. The execution court has fixed the date.
Have the server copy of the order?
I have the server copy of the order.
Leave to file with the
Lordship,
server.
kindly be maybe pleased to take up the matter tomorrow, my lord. Extreme urgent matter, my lord.
Please file it, it will appear. Give the date.
But she tried to mention a matter, my lord, without it's my mistake, my lord. I'm paying for release of item number 1236. My lord, may I hand over the copy of the order?
Item number?
1236 of the monthly list.
The monthly list. Have you informed have you mentioned this upon informing the other side?
Kindly. May
side has to be informed.
It's my mistake. Kindly keeps it tomorrow, my lord, to be mentioned, my lord.
Please mention tomorrow in the presence of the other side. To mention the other one. We mentioned the
Yes. Your Lordship asked the advocate record to bring the senior. Your Lordship asked the advocate record to bring the senior. Senior কি করা হবে?
Yes. Call the next matter.
On 01, my lord, I am for.
It's just hearing.
Yes, my lord. My
Yes,
lord,
Mr. Mukherjee, which matter you are appealing?
my lord, I am for the plaintiff petitioner before your lordship. My lord,
Yes.
Plaintiff sued for specific performance of contract in 2013. After
What is the stage of the suit?
still,
What is the stage of the suit?
my lord, order 39 1 and 2, and my lord, order 6 rule 17.
Order 1 rule 10 has been disposed of.
No, my lord.
It is pending.
Is pending, my
What
lord.
is the next date fixed?
Next is, my lord, 22nd July 2025.
22nd July 2025.
Yes, my lord. 3 application, my lord, are pending.
Who are you in the suit? Plaintiff.
Plaintiff petition.
The application is otherwise ready. Objection has been filed.
Yes, my lord.
Ashwin. on 23. This matter was
Your Lordship, I am for the plaintiff.
Yes.
Application is for transfer of mat suit number 188.
Application for
Transfer of mat suit.
transfer.
Yes.
For want of determination, I do not. This matter was mentioned citing urgency.
I appear for the plaintiff petitioner, Your Lordship.
Yes.
This is my application seeking direction for expeditious disposal of suit, my lord, partition suit. My lord, I have to make, the defendant has adopted a dialectic tactics, my lord, and on each and every step has been seeking adjournment. Twice the cross-examination of plaintiff witness was closed, then reopened again at the instance of the defendant, and again at the defendant's witness stage.
What happened on 10th of April 2025?
It was again adjourned, my lord, and it is fixed for defendant's witness on 9 July, my lord.
9th of July.
Yes, my lord. Day after day, they are filing another frivolous applications
This
and taking.
application on what?
Lordship, I appear on behalf of the petitioner. This is a matter for expeditious disposal of the matter.
On the previous occasion, the petitioner moved an application as per the direction of Honorable Court for no adjournment, but the petition.
Is that order?
And it's a page 41.
Page
41.
41.
Yes, Lordship. Thereafter, the.
You are opposing.
My petitions are pending. Application pending.
What are the petitions pending?
But applications which are pending.
What are the applications which are pending?
One substitution application pending. It's not substitution. It's just recording the date, which is at page 44.
Order 22, Rule 10.
Page 44.
Tell me what are the applications pending?
Yes, Lord. Order 22, Rule 2.
Order 22, Rule 2.
And one application which is at page 54.
What is the application for?
This is for, my lord. Yes, give me a moment. Illegal installment by the defendant in
Opening of a grill gate.
Grill gate.
151 application.
151.
Dated.
But these are all dated.
All on the same date.
No.
Different.
No, 151 is dated.
151 is dated, my lord. I'll just inform. 21/3/23.
21/3/2023.
And the substitution application is dated 15/9/21.
Any other application pending?
No. But the next date is on 1st of July.
1st of July.
1st of July for hearing of these applications.
For, my lord, this is fixed for police report because police help was allowed.
Yes.
And PH.
For peremptory hearing.
But court has said that I will hear all the applications. Directs the learned trial judge to dispose of the applications within a month from 1/7.
The main petition is pending for 17 years.
This application under Article 227 of the Constitution.
নিয়ে নেবো ওটা। ঠিক আছে, হাত মারি তবে না।
This matter was mentioned citing
Adjourn it. Adjourn it, not dismiss.
fixed matters, no. Urgency at the time of mentioning, not a single advocate excepting one appeared. Yes, from 2 p.m. All these are mentioned matters. Citing urgency.
Urgency matter is going on.
That is why I am telling you urgency at the time of mentioning.
11:30
Yes.
Defendant is the petitioner.
You are appearing.
Defendant is
Yes.
the petitioner in a suit for declaration filed on 24th July 2020. Order 26 Rule 17 has been filed.
Petitioner. ওদের আইটেম নাম্বার কত?
113 হলো। Just a minute. কি হলো?
Shivaprasad Chaudhary versus Vishwanath Bagh.
Yes, that I am doing.
Yes.
But I am opposite.
Problem.
No problem. Now
Problem
clear.
is the my landed senior, junior is here. I do understand.
Oh,
that
he thought he was opposing Mr. Basu.
Yes, I am the
He told
opposite.
me I am leading in this matter. Mr. Dobi Prasad Mahato is here in this matter.
Yes.
Hello, Order 6 Rule 17 filed. Admittedly.
Order
barred.
6 Rule 17.
Not by
Admittedly.
admitting the barred by limitation. He is now challenging the deed is void. Knowledge was wrong prior to that. Admittedly. Will kindly come to the plane.
So what happened? That was allowed.
That was allowed.
Had it not been admitted case, my lord, I could not move it. But admission, I can show to your lordship. Kindly come to page
Issue of
46.
limitation, Mr. Basu, I am keeping it open.
This is admitted, nothing, no.
I am keeping it open.
Then the amendment has to be
And
allowed.
what also keeping it open? And that the miss question.
Then, well, kindly
It has been allowed.
that kindly come to 46, page 46.
Page 46.
This is the, my lord, one partition suit. Where is the, kindly come to page 49, paragraph 8.
Yes.
1, 2, 3, 4, 5, 6,
Plaintiff
7.
obtained certified copy of that sale deed
Yes,
4129.
he stated that in the year 1978, Jyoti Baganda Bagh already sold to the defendant number 2 plaintiff. I was surprised hearing the fact and transfer the such and such suit property. Plaintiff obtained certificate of the said deed on number such and such for the year 1978 after searching. So it's on that he has the knowledge
On the date of filing of the suit.
of the partition suit. This is the pleading in the partition suit.
This is the pleading in the.
Partition suit.
But Mr. Basu, at the time of amendment, can it be looked into
Only, my
the
lord,
plaint of another suit?
Normally, my lord, as an officer of the court, I can say, order 6 Rule 17
Mr. Basu, I can do one thing.
to be allowed only in case where
It's expressly barred by.
expressly.
I appreciate that. But you will be citing decisions, yes, merits of the amendment, other documents you cannot consider. So
This is the document
how can this plaint be considered?
At the time of order 6 Rule 7, other document can be relied upon. It is under 711. They are also
Order 711 is only the statements made in the plaint.
plain. But now your lordship's court has elaborated that the document which you are relying along with the plaint has
That can be looked into. That can be looked
I
into.
just only
But this is not the document which was annexed.
here order 6 Rule 17 there is no bar.
No, but
Order
this
6
is.
Rule 17 application there is no bar.
No, did you produce this along with your written objection?
Yes.
Show me that. You have produced this before the learned trial judge.
Before the learned trial judge.
Show me where the learned trial judge took into consideration this fact
Not
that you have produced the plaint of that suit.
Just a minute. Kindly.
Oh, 923.
Yes.
Yes, yes.
That is there. But I just for your lordship recapitulation, kindly recall 2011 Supreme Court page 41. But court has just ignored that.
What is the finding of the court on this?
Just ignored that, my lord. Or in the mind order case rule 17, all amendments should be allowed. But exception is there. One exception is there that if it is on the face of it by limitation, court should not.
And within knowledge, 3 years.
That but I did not see.
No, that this suit was filed when?
This partition suit
Was filed when?
just it.
2016.
2016.
2016.
Which suit? The partition.
And this application for amendment filed on?
After filing of the written statement by
Just
the.
it, I'm
No,
giving
the date.
27, 27, 27 can they come? 13th March 2024. Otherwise, my lord, I will not travel a lot.
That will be an issue in the suit.
So how can
Starting
we,
from the date
how-
of the amendment application
how
filed.
it can be?
Those,
No,
those line of decisions are
those
there.
lines usually relate back to on that date. If
No,
it
that is
allowed,
why I'm saying it will not relate back.
It
I
will
will
relate back.
restrict it. No. There is a decision, Mr. Basu. In certain cases, court can restrict.
Court
the-
can, but in a case where
I'm restricting that with effect from the date of filing of the application.
that, my lord,
If it is barred, it's barred.
kindly consider that had it been a case, my lord, arguable case. Should I trouble your lordship? Here, my lord, on the, not my document, documents of the defendants categorically, plaintiff categorically suggest that is barred. My lord, kindly once peruse that it opposite judgment, my lord. Thereafter, yeah, it is up. Then the ball is my lord's.
The Basu will not give the book. Will give only the.
My lord is now habituated with this. We old people are habituated with the books only now.
Yes, paragraph.
The entire judgment is on that.
Which paragraph you are trying to rely upon?
Just a minute.
You are trying to rely upon on the point of limitation.
Only-
Paragraph 32 and
only-
33.
Yes.
32 and 33.
Yes. Only on that point. Huh? 2011 AIR 2011 Supreme Court page 41.
ফটফট করিস না, চুপ করে দাও না।
The trial court has completely ignored that.
Yes, this is that decision which I was telling you. Kindly come to paragraph 32.
33.
Even 32.
32.
Even though the prayer for amendment to include the relief of specific performance was made about 11 years after filing of the suit, and the same was allowed.
Just a
Page
minute.
32, paragraph 32.
It's not telling my AIR is there.
No, this is SCC.
Yes, starting which starts with paragraph.
Starts with, oh, you are having the AIR.
Yes.
Starts with even though the prayer for amendment to include the relief of specific performance.
Yes, paragraph 35.
Even though the prayer for amendment to include the relief of specific performance was made about 11 years after the filing of the suit, and the same was allowed after 12 years of the such an amendment in the facts of the case cannot relate back
Right.
to the date of the original prayer in view of the here in this case, so
No,
cannot
but
relate.
whether it is allowed at all. See, all the judgments, Supreme Court categorically said that all amendment, if the other side can be compensated by cost, should be allowed. Exception is when it is barred by, on the face of it, barred by limits.
Limitation is the big question of fact and law. So that will be that
ordinarily.
Ordinarily.
That, but in this special case, if you have admitted this, how can you say it's a disputed question of fact? It's your complaint.
If your lordship kindly come to the improved order, this is
No, please come to your plaint first.
After filing of the written statement, I came to learn regarding the facts and therefore I filed this application.
Come to your plaint, page 46. Is it not your plaint? Who are you? What are the name of your clients?
On the last occasion, your lordship directed to the file a supplementary affidavit in connection with the plaint of 83 plaint.
83.
Yes, that plaint, that
Yes, sir. Where
supplementary
is that, Mr. Basu? I have
supplementary
directed.
affidavit also been
83 suit. What is the 83 suit?
On that shoot, any instruction regarding 41 sales certificate has been incorporated or not, that is the
What is this suit for?
May not be relevant according to my
No.
16 suit is relevant.
declaration and permanent injunction.
Oh, in that suit, they have filed an application for addition that has been rejected. But I think that is turned on that. I don't know why my lord has directed.
I do not know. Mr. Mahato will be the best person because
he has not said me. And according to him, these also suggest they have the knowledge.
Because they find the application for additional party.
Yes, that is there. I have directed. They have now filed they have complied with the order. Please come to 46. What is the name of your client?
Madam,
You are Vishwanath Bagh,
yes.
Boshanto Guchait, and Bijoli Jana. You are representing these three persons?
No.
Please come to page 46.
49 then.
Page 46, it's your plate. You have filed a suit.
Yes.
Please come to paragraph
8.
8.
Page 49.
Please kindly come to the middle. This is the sale deed which you are now challenging. 4129 of 1978. So this you had knowledge in 2016. And this suit was filed on? Mr. Basu, this suit was filed on 2020.
This suit, this is 2020.
2020. So you had knowledge?
No.
What no?
Paragraph 8 টা দেখো না এখানটা আমার টাটাকে সুবিধা হবে মার্ক করা আছে না
This was your, Mr. Basu, is it the same challenge is there? Because in that suit, he said this deed could not be executed by, said Jyotindranath Bagh as he died long before the date of execution.
So they know that there is a wrong
So
exercise.
this amendment is for that. Show me the
Yes.
amendment.
Amendment, my lord, at page 27.
Page 27. What is the ground of challenge? Same.
Yes. Come to 7B, page 30, 7B amendment prayed for, or in page 29.
Yes, same thing. Prior to the
Schedule 1.
procured by false personation.
Same thing.
In fact, that prior to such and such. Same thing.
Well, this is coming from sales certificate B number 21 of 1941.
No, sir. Kindly come to your plaint. This fact, there you have challenged that.
That deed of sale come from the sales certificate number.
From wherever it comes, you had the knowledge of that deed. You did not challenge at the time of filing of the suit. 3 years from that, even assuming from the starting point of filing of that suit, even then it's barred.
These grounds of limitation.
The question would be whether you could have challenged in a suit of 2020 even.
I am not saying that.
That would be the question.
No, if your lordship plaint are there.
Start.
না 2016 2020 আমাদের প্লেনটাতে নতুন প্লেনটাতে না
Yes.
No, my lord, if your lordship kindly, page 22, the plaint,
22, yes.
page 10 is the plaint.
In the plaint, you have not stated anything about that deed of 1978.
It's 1978, my lord.
You have not stated. But in a suit of 2016, you had the knowledge of 78 deed, and there you have stated that that deed could not have been executed because of certain fact.
But if your lordship, no, my lord,
But no.
kindly I take some instruction regarding my lord.
Instructions,
No, I don't know, just
you don't know.
regarding my lord, 1978 deeds which has
You
been
may not know, but the documents
on this ground, my lord.
Yes, this is your trade, sir.
Some, my lord, if your lordship kindly taken up tomorrow, I will do this. Kindly allow me.
I will again forget. And Mr. Basu will come and take another new point.
Well, tomorrow, not
Mr. Mahato started on a point.
previous
Mr.
occasion, your
Basu will
lordship,
take another point. Tomorrow he will take another
been taken by Mr. Mahato on the last occasion, and your lordship directed to the file a supplementary affidavit.
It was a different day.
Only I
Different day.
instruction.
He's taking advantage of that fact by short memory. He's taking advantage of that.
Kindly taken up tomorrow. I will. And
also is trying to take advantage of that.
Only one correction is required. If your lordship
Correction.
Yes, in the cost title, both are plaintiff.
Yeah, that is the problem on
Taken
that.
up tomorrow. I will only some instruction.
For that tomorrow is not necessary.
No, for that not tomorrow. But I will take instruction regarding my clients has knowledge regarding that 78 deed.
This is your plaint.
Very well, my lord, if your lordship kindly taken up tomorrow. Kindly adjourn today. Knowledge.
Half an hour gone.
Just no, भूले जाओ सब.
फोल्ड किया हुआ बस लेके रखने के भाव कर हाँ सब धो देता नहीं पसार देता नहीं उठा देता नहीं फोल्ड कर देता सब कर देता नहीं ओकर बाद फिर
normally my lord takes
morning
morning है तो बोले यार morning है तो
क्या किए ये देखें कुछ नहीं किया ना मेरा सोना जाइए
Yes, who is appearing?
Oh, that पापा जी जल्दी कीजिए मेरा केस पकड़ेगा
This matter was mentioned citing urgency.
जल्दी कीजिए मेरा केस पकड़ेगा मैं कोट पहनूंगा ले तब ओ पापा दही हाँ जाइए माँ के साथ पी लीजिए दही जाइए इसको खोल कर पीजिए एक चुटकुन पी के छोड़ दी आप पी लीजिएगा हो जाइए तक पता हवा खुलो झारा खुलो जय
चलो बेटा
दरवाजा काहे खोल रही हैं बंद कीजिए
This matter was mentioned citing urgency. Call the next matter.
Wait a minute.
This matter was mentioned citing what problem? Any problem?
Lordship, it was 1453. So
1453 is the
34 was called. That is why, Lordship, I am for the opposite party.
1453, 34 call করলেন কেন?
I even asked him, that is why. Lordship, I am for the mother opposite party.
ওটার অর্ডারটা রিকল করে দিন 1434 এ দেখো তো 1453 তে অর্ডার করেছে না 13 20 ঠিক আছে 1453
My lord, in this matter, Mr. Olun Pahari is appearing, my lord. He is on legs. Kindly minutes short pass over, my lord.
no short passover business sir fixed matter urgency you have mentioned please
My lord, I am not the. He requested me, my
then it
lord.
will revert back to the original position
My lord, kindly, my lord.
no
My lord.
no kindness now yes
I am for now, this is my affidavit of fact. My lord, suit for injunction was decreed ex parte. Subsequently, my lord, I find that in the judgment, my lord, there are some typographical mistake. I made an application under section 152, that is at page 27. My lord, instead of 16 and a half, the one has been missed. It has been made, my lord, 6 and a half. That is required to be corrected. Trial court had rejected the application.
correction of the degree
My lord, if your lordships kindly come to my application.
no appeal has been preferred
No. Ex parte decree.
so ex parte decree functus officio court says functus officio what can be done Mr. Bahato
But therefore
After-
provision is there for correction.
if the court do not have the power to function to touch the records
Let item number 1453, I was on my.
Yes, call the next matter. Ashwin, this matter was mentioned citing
This is my application.
Sir, I have been instructed to appear on behalf of the opposite party.
instructed to appear. You have not got copy.
No, this is first time.
Motion stage.
No caveat.
No.
Yes.
The application, the issue involved in this matter, my lord, I am the PMT of the property and the opposite party is the preemptor, my lord. Question arose during pendency of the appeal. The preemptor sold the land upon which is the original owner. What will be the effect? That has not been decided by the Landlord appeal court. Kindly come to judgment starting from
Preemptor, this application is on the ground of co-shareship
co-shareship and vicinage.
and vicinage.
Co-shareship has been gone, but it has not been allowed. But
No, which land he has transferred? The adjoining land or the suit property?
the adjoining land upon which he is the owner of that land.
No,
Preemptor.
but the preemption is on the ground of co-sharer as well as adjoining owner.
No, co-sharer, yes, co-sharer has been, my lord, that ground has been gone, he has not been allowed. But vicinage
No,
on the
no,
ground
I'm
of
asking you, the preemption application was filed on twofold grounds.
Yes.
Co-shareship as well as an adjoining owner.
Yes.
Now, which property he has transferred? The adjoining property or the suit property? You submitted that during the adjoining property has
transferred.
and the ground of co-shareship still remains.
So that co-shareship has already been gone because court has not allowed that co-shareship. Only allowed the vicinage ground on the adjoining land. That is, my lord, kindly come to the judgment of
Show me that ground that he has transferred during the pendency of the appeal.
internal page 5 of the judgment. Learned lawyer for PMT submit that during pendency of the
No, did he transfer the entire portion of the adjoining land or a part of that?
that has been, my lord, I asked for produce that deed of document.
No, what is your case, sir? Whether he has transferred the entire property at the adjoining property or a portion of that?
That is, my lord, kindly see that entire property.
Entire property?
Yes, that land.
Show me your case made out that the entire property adjoining.
It will appear from that order itself.
Yes, show me that portion.
Page 5, first, second.
Page 5 of the appellate court's judgment. Yes. Yes.
Learned lawyer for PMT submits that during pendency of the misappeal,
Learned lawyer for the PMT.
Already sell out his land on the basis of which he claimed preemption. the preemptive prays for permission to give additional evidence in
That is your submission. What is the finding?
heard the learned lawyer in respect of the petitioner preemptor, there is neither any such abatement pleading in the written objection. How it is possible? Because during pendency of the filed by the preemptee in the mispreemption case, nor add any fact by way of amendment for which intent to adduce additional evidence. It is not the case that the preemptee, in spite of due diligence, could not produce any such document at the time of evidence in mispreemption case. The certified copy of deed which the preemptee
Mr. Rai, is it a fact that you have transferred the entire portion of the adjoining plot?
So for my lord,
What is the ground of preemption?
vicinage.
Only vicinage,
Only vicinage.
not co-sharership. If you have transferred, Mr.
Yes.
Rai, the adjoining plot during the pendency of the appeal, there is
So
no
for order
cause of
40
action.
rule 27, my lord, I don't have any application. Order 40 and rule 27 application is not here. And so the deed is concerned, my lord, I don't know what deed, because the deed which it appears, my lord, there is no discussion to that effect before the court of appeal because order 40 rule 27 has been rejected.
But that's the infirmity. If the order 41
Yes, my lord,
is
because
pending,
it is,
that has to be remanded then.
that is a post-suit. This is a
Post-suit phenomena.
yes.
That's
So
a
that's why, my lord,
phenomena,
it is,
but, order 41, rule 27. It is, if it is for that he wanted to produce certain deeds to bring to the notice of the court the fact that the adjoining land, on the basis of which you claim preemption, you have transferred, cause of action does not survive.
yes, but not only from the date of filing till the passing of the order, it should remain. That is
Yes.
it.
So if it is not there, preemption goes.
May I have your lordship, a copy will be given order 40 rule 27, so I can come and submit with your lordship. There is nothing in it.
What happened to the order 41 rule 27?
That has been rejected.
That
Order 41 rule 27 rejected on what ground?
There is no amendment in that. There is nothing. They did not pray for any amendment of the original objection.
No, order 41 rule 27 rejected in isolation of the hearing of the appeal.
No, it appears well in the body.
Body of the
Along with the
Along with that is not the case.
last paragraph.
Where is the order 41 rule 27? Where are the deeds?
That my lord, it was not allowed.
The two documents which are only relevant, and you have not annexed that.
That is what my lord I am precisely praying. A copy, so I can come back here, lordship, and say that no, there is nothing in it. Merely
On law, Mr. Rai is not disputing your submission.
Yes.
But on facts,
that is all.
just consider that.
Let the matter. I shall take the copy of that deeds and my lord.
You don't have the copy of that.
At present moment,
And you have moved that matter. That is your only case made out.
yesterday,
And you have mentioned.
yesterday I have given that matter. That's why, my lord, I have.
But you have mentioned this matter for taking up at 2 p.m.
I am extremely sorry, my lord. Yes,
Mr. Rai, you have been served with a copy of the revision application.
No. This is the first time.
When this matter is taken up for hearing, the learned advocate
ওটা আমাকে এর মধ্যে দিয়ে দিন, আমি ইনস্ট্রাকশন নিয়ে নেবো।
ওটা এখন না, ওটা তো বললাম 4:15, 4:10 ডাকবো। 4:10 বলেছি, ওই ফিক্স ম্যাটারটার আগে ডেকে দেবেন, কারণ উকিল বাবু নেই তো, ওনাকে 4:10 বলেছি। ইয়েস, কল দ্য নেক্সট ম্যাটার। 190.
I appear for the petitioner.
Yes, Mr. Basu.
May it please your lordship. Well, my point of argument would be this: that in an eviction suit, a tenant is always a defendant, but a defendant is not always a tenant. Why I say so, my lord?
What is the impugned order, Mr. Basu?
The order impugned is, my lord, the rejection of my 7172, and straightway without any application under section 73, and without
required. Mr. Basu, not required.
Well, I say, my lord, the landlord-tenant dispute is there. Prima facie, my lord,
show me your 72 application.
The landed judge, my lord, was obliged to decide, my lord, the landlord-tenant dispute prima facie.
Show me your application.
Yes.
Under
My lord, kindly comes to
page 18.
Yes, my lord.
Yes. What is the dispute which you have raised?
My lord, I say, my lord, the plaintiffs are not my landlords.
Yes. Who are your landlords?
My lord, so far as
merely by saying plaintiffs are not the landlords will not do.
My lord,
you have to make out a positive case.
My lord, I say,
what is your positive case? Who are your landlord? What is the basis of your induction in this property?
My lord, my basis of induction, my lord, my father was inducted. My lord, by my lord, somebody, my lord, if you
show me your statement in section 7.2.
Yes, my lord.
Who is that somebody?
My lord, kindly comes to my written statement.
Not in the written statement. 7.2.
Very well. Kindly comes to my lord, my 7.2 application.
Yes. Show me who has inducted your father.
My lord, kindly comes to my lord, page 18.
180, yes. Kindly come straight away to that. Who inducted your father?
My lord, kindly comes to my lord, paragraph 3.
Yes.
My lord, subparagraph 1. In the year 1982, the father of the defendant Shanti Sutradhar came in possession of the suit property as a premises tenant by the erstwhile owner Bimal Kumar Singh.
Paragraph 3, Roman 3, III.
No, I. 3I, page 18.
Oh, 3I. Oh, page 18, yes.
Has the lordship got, my lord?
Yes.
In the year 1982, the father of the defendant Shanti Sutradhar Singh, deceased, came in possession of the suit property as a premises tenant under the erstwhile owner Sri Bimal Kumar Singh, saying this is against a monthly tenant such and such. Only according to the English calendar, an additional fee of rupees 50 for electric charges, and he had started occupying the same for commercial purpose. Thereafter, the said premises was developed by construction of a new building, and the predecessor interest of the defendant was handed over of the suit property as a premises tenant for the commercial purpose by virtue of a tenancy agreement under the terms and conditions specifically mentioned therein by the original landlord.
Since this what happened after that?
Number after this, since during time, since Bhuma Singh or he stopped taking rent from the father of the dependents.
What did you do after that?
Number so far as after the father died, and we say that we had been in continuous hostile and possession of the property.
Adverse possession.
Adverse possession of property for more than 12 years and at almost 20 years old.
Basu, show me the law. If your initial induction is as a tenant,
my induction was not a tenant. My father's induction was a tenant. And what I say, my lord, I have specifically raised a dispute under section so far as ingredients of 7.
Dispute. Show me the dispute.
Yes, my lord. Kindly comes, my lord.
Yes.
My lord, kindly see paragraph 7.
Yes.
My lord, kindly comes to my lord, page 15, paragraph 7.
Page 15?
Yes.
What is page 15? What is page 15?
May I kindly see, just before that, page 14, paragraph 6. that the defendant stated that Shanti Sutradhar died intestate such and such, living behind his wife and two sons and his legal.
Basu, you can raise a dispute under section 7.2. Show me from your application under section 7.2. Don't go to any other document.
Very well. But this is 7.1.
The 7.1, you cannot raise a dispute. Dispute, you have to come under section 7.2.
But kindly see paragraph 7, page 22.
And in section 7.1, what was your prayer?
Malad, in 7.1, my prayer was that granting leave to deposit rupees 250 only.
In the name of?
So for the prayers are concerned, those are not apparent.
Have you deposited under section 7.1? In whose name?
That 7.1, 7.2 were initially allowed. Subsequently, order was recalled by
file 7.1, so it's a no dispute situation. When you file an application under section 7.1, it's a no dispute situation. That's the language of 7.1.
Malad, even if I say, Malad, the disputes, Malad, part say, Malad, if still exist according to my version, merely because my 7.1, 7.2 were rejected on the ground that it was barred by time. So far the provision is concerned, though I took a plea that my advocate did not.
By time, the learned trial judge is not required to consider that.
Now, Malad, so far as a landlord-tenant dispute, Malad, I have brought two judgments of this honorable court where, Malad, it says that if, Malad, there are allegations with regard to, Malad, landlord-tenant.
Even after the time, that has to be decided.
Malad, kindly comes to, Malad, I would show, Malad, two judgments, Buddhanath Kundu and Jiten Juadar. Barco?
Jiten Juadar, I think I appeared in that.
Yes. And Malad, your lordship argued this point, Malad, and this honorable court had accepted.
Don't rely on that.
No, Malad, I would rely because this is your lordship. Malad, when was at the bar, Malad, this was your lordship's point. And Malad, I got inspiration from that judgment, which was followed by Jiten Juadar by Justice Banerjee. And there was another judgment in Pramod Chakraborty, where I relied these two judgments in Justice Bhattacharya. Malad, kindly see, Malad, Jiten Juadar, yes. No, first, Malad, kindly see Buddhanath Kundu.
This is on 56 Act, Mr.
No, the principle is same. Then kindly see, Malad.
Basu, that's a distinction between 1956 Act and 1997 Act.
No, Malad, so far.
Supreme Court judgment is there, Mr. Amit Kumar. You know all these things. You are going back and these provisions of 1956 Act and 1997 Act has been thoroughly discussed on these judgments.
Then, Malad, kindly have a look to Jiten Juadar.
Lordship, may I just mention one thing? Suit has been decreed on 16th.
Suit has been decreed.
Then, Malad, but I was told that you fixed your argument.
This at the beginning.
Malad, here it says that cross-examined time was rejected.
Mr. Basu, a suit has been decreed now.
Malad, one sentence, if your lordship kindly record that so far as the points that I could have taken, Malad, those points, but
everything is there. You know the law
very well. But kindly record this one. Otherwise,
what records? Law gives you liberty.
Very
well. When this matter is taken up for hearing, the learned
So, even if I say, my lord,
Yes, call the next matter.
the mother was not made a party. Is hit by proviso order 1 rule 9. It's admitted in the plain that I would add them. I have taken also those points. Anyway, my lord,
Yes, next.
I'm great.
One. Yes.
The party.
Who is for the petitioner?
For the petitioner.
Yes.
Lordship, I am the tenant. Lordship, suit was decreed on the ground of reasonable requirement and default.
Decreed.
Yes. I preferred an appeal, Lordship, and occupational charges of rupees 6,000 has been awarded, Lordship. Only 196 square
Bhagwati,
feet.
you are moving this up 6,000 rupees.
196
square feet. Please try to fetch another accommodation in that locality
So that is
at an amount less than 6,000.
Lordship.
6,000 is the occupation charges.
Yes, Lordship.
So try to fetch an accommodation in that locality, similar area at an amount, anything at even 5,999, and please move on to that flat.
21 was the original rent, Lordship. From 21 to 6,000.
Chakraborty has a brave heart. Defense struck off.
If I share my experience, while I was there, a rent of rupees 1,500 was enhanced to 1,80,000.
Lordship, here, not only this, Lordship, Lordship, the landlord himself says that, Lordship, at best.
What I can do is that I can expedite the appeal. I can do that.
The solution
given.
No, that
the appeal was dismissed for default.
It was restored.
Restored.
Dismissed for default, and that was restored.
Where is the, by which order? Occupation charges?
Lordship,
What is the order dated?
yes, order number 43, dated 3rd of October 2023.
Order number 43.
Yes, Lordship.
And the cost title is not in conformity with the decree. He has
That is not in conformity. That Mr. Chakraborty will correct that. That may not be a problem. Order number 43.
Lordship. She has not made the co-defendants a party in the appeal. Yeah, she has not made the co-defendants a party in the appeal, nor in the revision.
No, where is that? Order number 43 is not the occupation charges.
Yes,
it's
yes.
the suit. Yes.
Title appeal number 42 of 2018.
Yes,
Lordship, this is CO number 89 of 2024.
No, কি দিয়েছেন file 978 of 2025 দিয়েছেন 197 টা হচ্ছে CO 89 of 2024. I was looking.
Order number 43, dated 3rd of October 2023, Lordship.
Yes, now I've got. Now I'm on the right file. Oh, 3 rooms.
Yes. Lordship, total 196 square feet, 3 rooms.
Total 196.
They have stated, Lordship kindly sees their application at page 37. They have stated that.
No,
It's not
your
fine.
client has stated that. That comes from the commissioner's report also,
Yes.
which they are denying. It is near.
This, you are exploiting for commercial purpose.
No.
Where is the locality?
Lordship near Shobha Bazar.
Botala PS, Lordship.
Botala PS near Satubabu Bazar. Bidon Street.
At page 31 is the schedule, Lordship.
And he himself admits it is 20 minutes walking distance from metro.
But in Kolkata, everywhere is 20 minutes walking distance from metro.
It is near Bethune Collegiate School, Scottish Church Collegiate School. This property is located.
Lordship, the schedule of the property is at 31.
Yes. 2 rooms on the first floor, 1 room on the ground floor.
Yes.
Ms. Chakraborty, any evidence you have produced to show the occupation charges?
No. Lordship kindly sees, comes to page 37, Lordship. This is the petition of the landlord, Lordship.
Defense struck off, Lordship.
Maybe, Lordship. So what? That doesn't mean that my right to appeal will go.
It was fixed for argument of the appeal.
Yes.
Item number? Yes.
Opposite party, my lord. Plaintiff opposite party. This was
Petitioners are afraid of you, Mr. Bose. Who has mentioned?
on the last occasion.
Have you given notice to them?
On the
My
last
lord, I am
occasion.
for the petitioner, my lord.
What are the, you have mentioned this matter for fixing a date. Prior to that,
Yes, that is I mentioned, and matter was mentioned. You are.
I am for the petition. I am for the petitioner, my lord.
yes. Yes.
This is the vacating application filed by my learned friend, my lord. Your
Yes, sir.
lordship
You
was,
said you will be appearing physically. For that, you paid for time.
my lord, that's true, my lord. But one of my relative expired today morning, my lord.
Yes.
Hence I could not appear physically before your lordship.
You can move virtually also. There is no difficulty.
If your lordship pleases, kindly fix up the date on Monday, my lord. If your lordship pleases.
Why?
No, I'm ready, my lord. I'm ready with the brief.
Then you can move. No difficulty. Yes.
Order dated 20th of February, my lord, wherein my deposition has been closed by the learned court below, my lord. This is a suit for partition, wherein the petitioner before your lordships are the defendants, my lord. Evidences were going on.
Order dated 20th of February 2025.
My lord.
That is under challenge.
My lord.
PW1 আমি চুক্তি করা হবে আর DW হচ্ছে সর্বমোট
Yes.
My lord, I never prayed for summoning Swapon Bormon, my lord.
So whom did you summon?
I prayed for German Roy, my lord.
German Roy?
My lord, if your lordship turns to order dated 24th of September, my lord, 12th of September 2024.
Now what happened? Your evidence has been closed.
My lord, my evidence has been closed, my lord. Summon was issued to the.
Was not issued.
Which order you said that German Roy was?
12th of September, my lord.
Did you furnish the particulars of German Bormon?
My lord. I have also prayed for issuance of witness warrant against this German Roy, my lord.
We did not file any requisites.
My lord,
it has been filed, my lord.
Order 16, Rule 10 not complied with. And not only that, my lord, my learned friend, my lord, possibly has missed out one point. The deed, my lord, which he has referred for his, my lord, the witness has to be material, that is the law subject to correction, and German was not a witness to the deed. How German?
No, he says, no, Swapon Bormon, in the order it has been stated that he wanted Swapon Bormon to...
He said German, I take him, my lord, he's to be correct. German is not a witness to the deed. He wants to prove it.
Yes, how German Bormon is a material witness?
My lord, the deed in question, my lord, which has been exhibited, deed number 2420 of 1978, my lord.
Where is that?
My lord, it is not with me, my lord, because it has been submitted before the learned tried court below. I have asked the...
Show me the copy of that.
My lord, it has not been annexed, my lord. I have asked the petitioner to get a copy of it.
If you have you given evidence?
No, my lord. The petitioner has deposed before the learned court below as DW1.
Material witness.
She has deposed, my lord. I have annexed the deposition also, my lord.
So what is the next date fixed?
My lord, the next date was on 16th, but the court is vacant. 16th of June. The court is vacant. The learned PO has been transferred.
Why, Mr. Bose? I will decide the main civil division application. Why are you interested in vacating the interim order?
Sorry, I could not. It is my incompetence. I could not.
But I do not know in which way it will go.
Yes.
Yes.
My lord.
Show me
The
how German Berman is related.
my lord, the deed in question 2420 of 1973 has been purchased by 4 persons,
Yeah, but-
including the father of the petitioner, this German Berman, my lord.
Is the
Photostat.
Photostat will do. German Berman is not a.
I will check. Yeah, I did not find. I find two witness. কি নাম ছিল?
Kasinath Berman, Nogen Berman, Sonju Berman, and Pohatu Berman.
But that is not there. German Rai Bormann is there.
German Rai is the son of Kasinath Berman, my lord. The one of the person who purchased the property, the co-schedule property of the plaintiff, my lord.
Come to a finding.
Ashun, this application under Article 227 of the Constitution of India.
My lord.
German Berman or German Roy?
My lord, German Berman alias German Roy.
German Berman alias German Roy as a witness. Full stop.
Application for extension.
In the light of the order passed by this court, yes.
minute from rejection of my application under section 10 of the Code of Civil Procedure.
Stay.
For stay of the subsequently instituted suit. My lord,
What is the subsequently instituted?
kindly,
suit?
do not look at the records now. I give you lordship, a bird's eye view, then I'll take your lordship to the. I am IFB. I used to produce alcohol, spirit, for which I needed broken rice. Now I issued a purchase order for the defendant to supply me in my suit to supply me broken rice. The purchase order indicated the quality and quantity of the goods. They breached both in terms of
where is the suit for
this-
damages?
in the same court, before Alipur.
No. Show me the plaint.
My plaint is at page 25.
Your suit is for damages.
My suit is for damages because they did not supply. Page 25. Oh, I'm sorry, my suit is at page 64.
Page
64. 64 is my suit.
Your suit is the earlier suit.
Earlier suit.
It's a money suit.
It's a money suit. Theirs is also a money suit.
It's on the self-same transaction.
Absolutely, on the same purchase order, I say, they did not supply, both quantity and quality wise. They say, they supplied quantity and quality wise. And, their
So your suit is for decree for damages.
Damages. Their suit.
And where is their suit?
Their suit is at page 25 for the billed amount. And, their plaint is a word for word, reproduction of their.
But what are the stages of both the suits?
Both, in my suit, issues have been framed. In their suit, issues are to be framed.
Written statement filed.
Written statement not filed. I am told, Milord, this day, Milord, we are going to file this. Milord,
You have to file the written statement.
yeah, because Milord, the section 10 was pending. So, Milord, written statement was not filed. Now, Milord, written statement is ready. We will file that.
It's both are at the same court.
Same code. But Milord, what I say is this, Milord, the taste of section 10 is whether, Milord, the decree in the first suit would operate as res judicata in the second suit.
But it's better considering the nature of the suits, both are to be heard analogously.
Milord, there was an application to that effect filed by the opposite party here in my divisional application. Milord, that has been rejected. They has accepted that. Milord, two applications were taken up together. One was, Milord, my application under section 10. The other application was, Milord, the defendant's application for analogous hearing under section 151. That is rejected. Both the parties have accepted that order. And Milord, any decree passed, Milord, dismissal, be it, Milord, allowing my suit, Milord, that would have, Milord, a direct impact on, Milord, the subsequently instituted suit. Because, Milord, I say, Milord, service, Milord, this supply was not effected. That is the sole, Milord, moot question to be decided in both the suits, whether, Milord, supply was effected in terms of the purchase order or not. I can show, Milord, from their plaint.
But Mr. Banerjee, your plaint
Yes.
is your written statement in their suit. Your plaint will be your written statement in their suit. Their plaint will be the written statement in your suit.
Milord, it's what to
Unless both the suits are heard analogously.
But Milord, that order is already, Milord, passed, which is not, Milord, asset. Milord, technically, Milord, there lies this
227 court can.
That's true. That's true. Milord, may I also serve upon the learned advocate who is representing them before the learned
In addition thereto, the petitioner will be at liberty to serve a copy of this application upon the learned advocate representing the opposite parties.
Suit for declaration and injunction. Suit degree. Appeal preferred by the defendant. In the title appeal, the defendant took out an application under Order 41 Rule 27, which has been allowed in isolation of the appeal. Appeal is pending. Order 41 Rule 27 allowed. On the ground, so to mark exhibit of the documents.
There's a Supreme Court judgment which says it can be.
May I just, madam?
Where is that?
I am on the point of res judicata because that point was sought to be raised in the suit. They got the opportunity to adduce evidences that they failed to avail of, closed, the trial court declined to give them opportunity.
41 Rule 27B.
Yes, my lord, but to that.
B is there. Even if A goes, B is there. My court's requirement. It's the court's requirement for passing a judgment, pronouncing the judgment. I think that is Order 41 Rule 27B is there.
Observation also.
My lord, kindly considers, my lord, one thing.
Mr. Basu accepted. Order 41 Rule 27A goes. Even then B remains.
For any substantial cause.
Yes.
But that opportunity to adduce those documents were before the trial court. Opportunity was given.
Sir,
But
I tell you, A, that is A. Yes, the court from whom appeal the decrees preferred has refused to admit the evidence which ought to have been admitted, or A, the party seeking to produce additional evidence establishes that not exercising, it's not that. Your case is that of A. So even if these are, Mr. Basu, all disjunctive.
All are disjunctive.
So, Order 41 Rule 27B, the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. The appellate court may allow such evidence or document to be produced or witnessed. It's the court's requirement.
My lord, so far as the B is concerned, my lord, those are to be read into with A and double A. Why I say so, my lord? The opportunity to adduce those documents which have been allowed by the first appellate court in an application.
What is the suit for?
Suit for declaration and injunction. I have sought for declaration that the defendant number 1 is not the wife of the predecessor in interest of the plaintiff.
What are the deeds for?
Deeds, my lord, kindly see the Order 41 Rule 27.
I'm asking you, what are the deeds?
But deeds, some document has been executed by the predecessor in interest of the plaintiff in favor of the deceased defendant, which I have sought for that he is not the married wife. Those documents where they had the opportunity before the trial court on which has been recorded by the judgment and degree in the suit. Kindly see the observation in the suit once. At page 25. Kindly skip the first 4 lines. It starts page 25 of the revision application.
Yes.
The defendant number 1 has not availed the opportunity to adduce a witness as well as documentary evidence in support of her case within time.
No.
As a result
of 25,
kindly skip first 4 lines.
First 4 lines.
First 4 lines.
Page 25.
Page 25 is the judgment of the trial court. Part of the judgment of the trial court.
Yes.
My lord, it
starts with for the plaintiff. No.
My lord, it starts with the it is an admitted fact. The page starts with it is an admitted fact.
No. I think the page is not telling. It's 24.
24 in my revision application is 25. It starts with the it is an
admitted fact.
Yes, and kindly skip the first 4 lines.
Yes.
The defendant number 1 has not availed the opportunity to adduce witness as well as documentary evidence in support of her case within time, as a result of which this court has denied the scope of the defendant to adduce further evidence in support of the case. The defendant number 1 has also preferred a revisional application before the Honorable Court at Calcutta against the order of this court passed on 7th of February 2014. In that application being CO number 1001 of 2014, the Honorable High Court has been pleased to affirm this court's order. Thereafter, the defendant has filed another petition dated 16th of December 2016, praying for marking some documents.
This is what is the order passed in CO 1001.
Yes, my lord, may kindly comes to.
Was dismissed for default.
My lord, no.
Yes.
That is, my lord, may kindly comes to page 51. Page 51. May I please? Kindly say, before the revisional court also they did not appear. Challenging the order of 7th of December, 7th of February, where the evidence was closed down for not showing due diligence to get the documents exhibited, which has been sought to be allowed under Order 41 Rule 27. The revision application was filed. Opportunity was granted. They declined before the revisional court also.
No. Where is that they wanted to produce this document and that was rejected? That is not
That
the
is
case.
the order of 7th of December, 7th of February.
All those are in the
No.
all those documents in the
Please give me a minute. The revision activity was directed against an order dated 7th of.
7th of, this is the order of 7th of
Where is
February.
the 7th of February 2014 order?
Yes, this is the order. That has been reflected in gist, has been reflected in the degree and judgment and degree of the trial court.
No. This order was by this, the evidence was closed.
Yes.
They challenged
this order.
Yes, they challenged in this. So whether those documents are relevant or not, that was not decided in this matter.
No, that was not been decided.
So it's not res judicata in that sense.
In my respective submission, my lord, if I'm fortified by the order.
That issue was not decided in that civil division.
That or they had the opportunity.
What?
They had the ample opportunity to adduce evidence and get the documents exhibited. The opportunity was not given for once or twice. Several opportunities was given. Kindly see the order, my lord. May I place the order? Relevant portion.
Plaintiff.
And the plaintiff. Kindly see the third paragraph. For the fourth paragraph, so far as the adjournment prayer is concerned. So far the adjournment prayer of the defendant number 1 is concerned, it appears that while order number 230, specific direction was given for fixing the date of the DW positively, that is the evidence will be closed. It appears that even prior to that, several opportunities were given to the defendant number 1 to adduce evidences. But ultimately, as no witness could be produced by the defendant number 1, the further adjournment petition was rejected on 18th of January 2013 and the suit was directed to be heard ex parte against the defendant number 1. Subsequently, after long delay, the defendant number 1 turned up and expressed her willingness to diligently contest the suit, and accordingly she was permitted to adduce evidences. But today against the petition has been filed seeking adjournment. It is submitted by the learned advocate for the defendant number 1 that the defendant number 1 is an aged lady and cannot move easily due to her back pain. However, from the conduct of defendant number 1, it can be presumed that she was just willing to drag the matter. Otherwise, she had the real intention to participate diligently in the proceeding of this suit. She could have taken recourse of the witness commission or such provision of the code of civil procedure, but instead of that, despite specific direction, defendant number 1 again prayed for adjournment. Considering the facts of the circumstance, I am not inclined to allow any further time to the defendant number 1. Hence, the time prayer for the defendant number 1 rejected. Evidence on behalf of the defendant number 1 closed. No one moves the defendant number 1. Hence, the evidence of the on behalf of the defendant is closed. This order was sought to be assailed in the revisional application at page 51. Even before the revisional court, nobody appears. The revisional court dismissed the revisional application. So this order is affirmed. No further challenge before the apex court. Subsequent that, after the dismissal of the revisional application, again another application was taken out on 16th of January 2016, which has been reflected in the order of the learned trial court. Kindly see the order at page 51. At page 24 of your lordship's brief.
I'm fixing this matter under the heading contested application.
My lord?
I'm fixing this matter requires a detailed hearing. I'm fixing this under the heading contested application.
Any content?
Yes. Yes, 15. Who is appearing in item number 15? None appears for the petitioner at the time of.
My application. Actually, this is my affidavit of service.
Lordship, the petitioner is the defendant in a suit for declaration, Lordship. Lordship, I have paid an application under Order 18 Rule 17 for recalling of the witness and also
Order 18, Rule 17.
Order 17 Rule 18, my lord. Order 17 Rule 18.
Order 17, Rule 18 or Order 18?
Lordship, Order 18 Rule 17 I have made, Lordship, for recalling of the witness, which have been rejected by this trial court, challenging which I have came up before your Lordship. Also an application I have made for
What is the stage?
Lordship, the PW1 witness has completed. Now it is a stage of
So you want to recall PW1?
recall PW1 on the ground of certain new documents which I have found out. I have
Where is your application under Order 18, Rule 17?
Lordship, page 24. And also, Lordship, I have made an application for granting leave to produce those documents, which also have been rejected by this learned court.
Where are the documents?
Lordship, documents are in the with the affidavit, Lordship, that is coming starting from Lordship, page 29. This is affidavit of discovery of documents. The contention of the learned court below is that I have not pleaded those documents in my written statement, Lordship. Whereas, Lordship, the statement in my written statement, Lordship, I have mentioned about the incident, and these are the documents only corroborating that incident also, only, Lordship. Since I haven't filed any application for amendment of written statement, Lordship, this has been rejected, Lordship.
No, what are the documents you want to?
Lordship, my contention is that there were
the documents.
Documents is that two agreements, Lordship, agreement for sale that were in.
Where is that? Where is that? Which page?
From page 29 itself, Lordship. From 32 is that agreement for sale.
No. I do not want to see the document.
Then, Lordship.
Where have you stated?
Page 27.
In my petition, Lordship.
Schedule of the documents, page 27.
Show me that there is pleading with regard to this.
Not a single.
Lordship.
Show me where are
Lordship, I am showing. Let me press the written statement, Lordship. Once.
Yes. Show me where is the pleading with regard to the first document, written declaration. Where is that? Which paragraph?
Lordship, kindly come to my written statement, page 15, my lord.
Yes, which paragraph deals with this?
Page A, paragraph A, my lord, plaintiff had taken accommodation loan amounting to such and such from the defendant and vide an agreement dated March 10, 2008, and in presence of plaintiff internally agreed to undertook, let the defendant occupy, possess, fully use the suit property till such time plaintiff returns rupees 6 lakh.
So where is the written declaration? Nothing has been stated with regard to the written declaration.
But Lordship, this incident I have mentioned in my.
But written declaration is not been pleaded. Now next.
Lordship, that declaration, Lordship, I have found out after my lord.
No pleadings. There is no basis in the pleadings. Yes. Item number 2.
Lordship, item number 2 is that regarding that police complaint, Lordship.
No. Agreement dated 7th of May 2006. Show me
Lordship,
pleadings.
Lordship, this is in connection with that agreement dated March 10.
Yes, gone. Next, the agreement for sale dated 20th of December 2006.
Lordship, that is also connected with that, Lordship.
Next.
These all the documents are connected with that except
there is no basis in the pleadings.
GD, Lordship, the GD I have mentioned.
Maybe.
In the,
this application under Article 227 of
the recent judgment is also saying that 2024 volume 6 Supreme Court cases and 2023 volume 13 Supreme Court cases. Paragraph
23. 64, 65.
এটা কত?
20.
But 24 is 6 SCC malad. Paragraph 23.
23.
Yes. আর এটা?
64, 65.
His case.
So this is pleadings are to be construed liberally.
No. Kindly see the next portion malad. কত paragraph?
23.
দেখেছিস তো না আমরা যে বলছিস it is settled.
Fact is that is well settled.
And the
Next.
second one is also malad in paragraph 64 65, that is beyond pleadings malad.
Evidence beyond pleadings cannot.
But Lordship, in the it has to be construed with the, I mean, extension of that, the agreement dated March 10, 2020.
This application under Article 227 of the
of 2017, my lord, may pray for expeditious disposal of this.
You did not make submissions when the matter was. Now Mr. Mukherjee has asked you to come forward. Court cannot permit two advocates to argue at the same time.
Item number 17, Your Lordship. This is a civil revision. Before making my submission, Your Lordship, I haven't served any copy to the other side because there wasn't any caveat. Your Lordship, this is a civil revisional application challenging the order, impugned order, which is page number 172, which has dismissed my application under Order 7, Rule 11 for rejection of the plaint. Your Lordship, there are a few inadvertence which has occurred on the part of the advocate on record. If Your Lordship grants me liberty to file a supplementary affidavit to bring in
The
record.
prayer of the learned advocate. Fixed matter to document. Pass over next.
Item number 9 for the petitioner lordship. In this matter, Mr. Shivaji Kumar is appearing. This matter is related to the expeditious disposal matter, lordship.
Expeditious disposal of what?
Yes, lordship. Kindly see the lordship the order.
The way you are filing the application for expeditious hearing, no regular matters can be taken up. That's the difficulty. Yes, what is the stage?
Evidence.
Kindly.
The matrimonial suit.
Sir, it seeks for cross-examination of PW1.
Yes.
Yes, madam. We will move this matter.
He sees in.
Yes, yes. Yes.
Yes, Lordship, sees later.
Decide who will move.
Sees me.
All right. Yes.
Lordship, this is the expeditious disposal.
What is the suit for?
It's a mat suit.
Who are
Lordship,
you?
Lordship,
Husband.
I'm the husband before you,
The
Lordship.
alimony order has been passed.
Uh,
Any miscellaneous case was filed.
Lordship, Lordship, there was a
Yes. This case, an order of alimony.
Lordship,
Are you complying with the order of alimony?
paid for 30,000. Lordship, the matter is in. Uh, evidence.
Madam, if you do not comply with the order of alimony, your suit has to be stayed. Instead of expeditious hearing, I will pass an order of stay.
Lordship.
You have not complied with that. This application.
My lord, item 20, my lord, just hear the facts.
So
My lord,
how much time we will take, because there is a fixed matter.
my lord, sometime at my lord, at
4 there is a fixed matter.
yes, my lord,
There is another matter. Where is Mr. Ghosh?
yes, that's at 4:15. Mr.
Yes.
Ghosh's matter 4:15.
Yes.
I'll take more than 4 minutes.
Within 4 minutes we will conclude.
No, not conclude, my lord. Not
Want to
conclude.
start. Commence the argument.
My lord, if you hear at least and you feel
Yes, yes. What is this? What is this suit for? Oh, no, what is the impugned order?
impugned order, my lord, is allowing a section 71 and 72 application.
You are the landlord.
I am the landlord, my lord. Rent of 1975 at 1,000 rupees increased to 1,200 rupees. Now, my lord, no payment at all, my lord, from 2008. Nothing.
No, 7.1 and 7.2 has been allowed, directing them to deposit. Why are you aggrieved?
Not deposit without ascertaining which is the period of default. Default is over 20 years. You can't do that.
Mr. Bose, what is
He was a
what is the ground?
Eviction. There is eviction.
What are the grounds?
Man, the ground is for eviction because he's a trespasser, because he has not paid any rent for the last few years.
This is not a suit under section 6.
No, certainly not. That was my contention.
Then how section 7.1 was
That is the contention that you cannot file under section.
Where is your plaint?
Manoj, the plaint is over there, Manoj. See. Manoj, it is annexure C. Annexure C. Where have I said that it is? If a person doesn't pay rent, Manoj, that's why I say, I mean, it's in corner of Southern Avenue and SP Mukherjee Road, flat, and with 1,200 from 75. And these landlords are 80 years. old, that is,
But Mr. Bose, the suit as you have framed,
yes.
it appears it's a suit under section 6 of the West Bengal Premises.
No, my lord, it is not. Kindly
The grounds have been mentioned.
My lord,
Grounds, reasonable requirement, default.
But kindly see, it's absolutely a defaulter.
Yes, defaulter is also one of the grounds of the
No, defaulter for more than, my lord, I mean, if you don't pay anything, then
that is the ground available under section 6.
lord,
If a suit is filed under section
I
6,
have not failed, my lord. If it's a trespass, if you don't pay rent over a period, then you become a
person
trespasser.
not paying rent does not become a trespasser. You can file a suit for eviction under because the suit as it framed is a suit under section 6.
My lord, there is no
one is maintainable.
My lord, there is no, my lord, if 7.1 is maintainable, my lord, if it is at all maintainable, you have to determine the period of default.
Show me the impugned order.
My lord, kindly see, my lord, may I just take 2 minutes, my lord, 2 minutes and then show the impugned order?
No, it has been held that there are defaulter from January 2015 to January 2019 for 49 months.
No.
So according to
without inquiry, my lord, because mother was conducting the suit, it was the late father, my lord, who died in 2004. Mother died in 2015.
All right. Copy of this application because there is no caveat.
There is no caveat.
So have a copy of this.
My lord, only
honest senior advocate appearing for the
direct without assigning, my lord, 7.3, what should be the
7.3 is defense striking out if there is non-compliance of 7.1 and 7.2.
Yes,
Mr. Bose, there is an order passed.
Yes.
So if they fail to comply with 7.3 is attracted, there is no requirement to file.
My lord, if you please do not take me amiss, but your lordship is more accustomed with these matters, and I'm not. My lord, a person, a tenant, suppose he doesn't pay for say 20 years, he'll be directed under 7.1 to render a suit at the rate of 1,000 rupees per.
Mr. Bose,
without ascertaining what's fair.
The law says at the rate last paid.
What is
That's the law?
My lord, it's a law.
And you will be, if you go through the judgments, there are also judgments which says
yes,
even time barred areas can be directed to be paid. They have to pay, but by limit, even if more than 3 years,
it is basically a ranked trespasser who has squeezed a tenant.
This is the protection when you file a suit under section 6.
I have.
Section
Well, that's my point. I haven't.
Plaint as it stands is a suit under section 6.
I have said he's a defaulted trespasser in the eyes of law.
Come, I will decide that. I've kept that point. I will decide that point.
Millard, also my humble prayer is also keep that with the, even and at the rate of rupees 1,200.
No, that cannot be increased. Mr. Bose, let me hear
yes
thereafter because at this stage that order cannot be modified in their absence.
No, I'm not saying, but your lordship has posed a question which I am sure they can't do from 2008. But can it be done? Condonation of about, I mean, for 20 years like this?
Yes, because yes, law says, and there are decisions which says even the time barred areas they have to declare.
So
one cannot ever file a suit
Because
against
at
a.
the point of time, this legislation was considered to be beneficial for the tenants. Now the decision is otherwise. It says it's beneficial for both. That's Nasiruddin's case. That is the latest view, which says earlier view was that it's this rent tax is beneficial for the tenants.
Yes.
Now the view has changed. It's beneficial for both.
Even for 20 years default, this can be done. I mean,
No, Mr. Bose, it's not that. If you prove that he was a default, you will get a decree. That's a different thing. But Section 7(4) gives a relief. If
so
this is
basically adjudicating that it is under the rent control.
you have other grounds. You have a ground of reasonable requirement.
No, Millard, my case, if I go for reasonable requirement, it will take 20 years. I do not, that's not, when we filed it, I deliberately, this has not been made, and it said you are a trespasser, you have not paid, there is no without authority you side, so go. That's the case. Please, Millard, do not treat it as a Section 1, and my contention was that.
No, I will not treat, because now, after hearing them, I will decide.
Yes,
whether 7(2) is maintainable or not, I will decide. All
Yes.
points are kept open.
And Millard, so if your lordship says, and without deciding the question of maintainability of Section 1, which was taken in my opposition.
So that has to be decided. I will go into that.
Very well.
That is the basic thing. If the Section 7 is not maintainable, that adjudication could not have been.
That
goes to the root of the matter.
That's Millard, that was my
Maintainability goes to the root
contention.
of the matter.
That was my contention without.
We'll consider that.
Right. I'm grateful. I'm sorry to take in.
No. It's nice to hear you. Right. Yes, call the fixed matter. Yes, for.
Has a report come? She cannot, I have received the email, Millard. She cannot say anything, Millard. But Millard, I have asked Millard, my friends, yes. What's Lordship saying? Rectification process have been done in that. It's better, Lordship Millard, transfer this to some other court, Millard. I have a Section 24, Millard.
Rectification is also done. Please, both of you, if you want, I'm fixing it tomorrow. You go through this report.
I'll kindly fix it then on Friday, my lord. Tomorrow I'll not be.
Please go through this report.
Millard, I'll try to bring the Section 24 here. Let it go, Millard, to some court where the Millard it's functioning. Otherwise, this problem of acquisition.
Tomorrow you have difficulty.
My lord, tomorrow on Friday, my lord, if your lordship.
Asun palate order record kore.
Ani now.
The Friday.
Which court? This one. Regarding what? Provided this is.
I'm yet to receive the copy of Section.
I'll give you a copy. 24th.
Give a copy to him and see if it can be, if it comes, then if it can be taken up on Friday. So the entire matter can be disposed of.
Grateful.
Extremely
It's a long pending matter. After
I have to go before the second appeal court.
Millard, and do whatever. In whatever, but this was the difficulty. It has now been solved.
Rectified.
Yes, call the fixed matter.
Grateful,
my lord. Report.
Yes. Yes. Another দেখতে দিন, দেখতে বললাম।
Thank you.
Yes. Where is Mr. Chatterjee?
Mr. Chatterjee is online.
Yes.
Milord,
All other matters, bole din.
6 minutes, Milord.
All other matters released excepting this matter.
6 minutes, Milord. There's nothing.
Yes, Mr. Chatterjee.
Mr. Mishra was to submit, Milord. He took time. Your Lordship, I recorded. I finished my submission.
You have finished your submission.
My Lord has recorded that, though I haven't.
Oh, you haven't? Then you can finish by 5 minutes. If it was recorded, then I can give you 5 more minutes to make submission.
Mr. Mishra was, Milord, very eloquent on the last occasion that he wants to submit a few decisions on that. Milord, if he submits that, Milord, then I can also, Milord, rebut that.
Well, subject to my lord's kind leave, if Mr. Chatterjee can conclude once, I will holistically consider everything.
No, I've got nothing more to add to whatever I've said.
Then it's ripe for me to, my lord.
He was making an allegation against the court that those who have recorded that.
No. Milord, I can have an allegation against your Lordship, but never against the court.
Yes.
My lord, as the civil revision appears to have been framed, and after hearing Mr. Chatterjee on the cause, there are
how much time it will take?
It is going to take time, my lord. Why? Essentially because very interesting and intricate point of law has fallen from my lord. I have burned my midnight oil, my lord, to get an answer to that.
So I have created the trouble.
Not the trouble.
For your Lordship's own self.
Which, my lord, is essentially.
Yes, Mr. Chatterjee.
For your Lordship's own self, my lord has created the trouble.
My lord, I cannot be so bold. I cannot say that. My lord has framed a question of law, and I have to satisfy.
I'm asking you how much time you want.
Kindly give me half an hour minimum. It will.
Keeps it tomorrow, my lord, at 2 o'clock. I will also be there, my lord, before your Lordship.
Mr. Chatterjee, 2 o'clock is a
understand.
thing because
What your Lordship is.
Mr. Chatterjee, I don't mind keeping it at 2 o'clock, but the other matters, I think you have a chance of a fixed matter tomorrow. One of your matters are fixed. So the only difficulty is, Mr. Chatterjee, you know, the motions will get stuck if I take up from 2 p.m.
Completely understand the pressure on your Lordship, my lord. We see it every day, especially on a Wednesday.
Only difficulty.
Any time suits your Lordship. Any time suits you.
If my lord may kindly consider, can it be possible that
Because today I have a difficulty, I have a meeting fixed just before. Otherwise, I could have continued. That's the.
Thank God for me, because I'm online. I want to be offline.
He's laughing at hearing that.
I'm very, very happy because I want to be online, my lord, in this matter, and I wasn't able to go to court today.
No, you want to be online.
Online.
Offline.
Offline. You said online.
Offline. I said I corrected it.
Oh yes. First you said online.
I said online, and then I said I want to be offline.
Only request.
Any day, my lord, please.
But it is on Friday, my lord, subject to my lord's completing the board 4 p.m. onwards till we finish. Let it be done.
On a Friday till we finish, Mr. Mishra.
Friday te ki
I have no.
Friday problem holo 3:30.
3 p.m.
My lord.
Friday.
3 p.m.
But again, 3:30 means.
3 p.m. কোনটা আছে বলুন তো? Oh, Friday. Friday, Mr. Chatterjee, that IFA matter is fixed.
The IFA matter will not take much time.
But
IFA, my lord, is at 2:30 if I'm not mistaken. 2:30 or 3.
3 p.m. 3 p.m.
Tale mushkil. Then fixes it at 4. If there is no 3:30, there is no problem. It should be over by 4 o'clock.
Without getting influenced by other matters.
Contempt একটা 10. Contempt একটা 10 না ডিভিশন বেঞ্চ আছে আবার।
তাহলে মুশকিল হবে। Then on Monday or something.
মানডে কিছু আছে? কালকে আছে কিছু? কালকে বোধহয় একটা ফিক্সড আছে না? সোয়া চারটে।
Tomorrow, I was told by Mr. Jishnu Chaudhary that there might be a 3:30. In another matter, he told the court that there might be 3:30. But I'm not sure. My lord fixes it tomorrow. There is no problem at all. If there's 3:30, accordingly, we'll do.
সোমবার ফাঁকা আছে? হ্যাঁ,
Huh.
মানডে,
But if Tuesday, no, 3 specially fixed.
Tuesday, Tuesday fixed. Tuesday 4 p.m. is fixed. Wednesday,
DRT is on 30th July.
হ্যাঁ,
DRT
বুধবার নেই। Wednesday, Mr. Mishra, Wednesday, Wednesday কত তারিখ হচ্ছে?
As directed by my lord. 10:30 to 3:30 Wednesday, let this subject be.
I would love to fix this matter at 10:30. But Mr. Chatterjee has to take responsibility on the next Wednesday.
I'm always there, my lord. Pushes the blame on me. I have got no problem.
26th. বুধবার কিছু আছে? ফিক্সড আছে 4টের সময়? বুধবার দিনই রেখে দিন। উকিল বাবুরা রাজি হয়েছে, না হলে আবার এক্ষুনি বলবে হবে না।
No, I am not. I am always ready. If I have a problem, I'll tell your lordship. But never say that.
উকিল বাবু রাজি হয়ে গেছে, আর অন্য ডেট দেবেন না, বলবে এক্ষুনি হবে না। আসুন।
Wednesday.
Mr. Learned Advocate appearing for the
1 to 5, my lord.
opportunity number 1 to 5 commences his argument but could not conclude due to paucity of time. Mr. Chatterjee, Learned Senior Advocate, appears for the petitioner. So, Mr. Chatterjee, your interest is protected through online.
I'm sure, my lord, the person who is there before your lordship representing me, my lord, has heard that.
Appearing for the petitioner is present online.
Online, no. Present before your lordship. That is
present through virtual mode. No. You are virtual mode. I do not know where you are. You will say I were physically present.
I am always present before your lordship.
বুধবার দিন করে দিন। Next Wednesday আর কি। Next Wednesday is 25th. 25th at 4 p.m.
Will take a little more time than after. Till it ends. In that case, my lord, 4 p.m. we start and we conclude it.
Please conclude. I will take
I'll do my best.
Mr. Chatterjee agrees to that.
What did I agree to, my lord? I just didn't hear that. What did I agree to?
That you can't hear. Everything else you have heard.
I asked this question to myself, my lord. What did I agree to?
So grateful.
It will continue. If it is not completed prior to 4:30, it will continue after that. That you have agreed.
My lord, may I have your lordship's kind indulgence? One order was.
Senior is there. He is opposing your prayer.
He is not in the matter.
I am opposing even then.
Deny he is your senior.
No. I'm not denying. Guru is a guru, my lord, always.
But I'm opposing.
Order has not been uploaded, my lord. The CO number and the list.
দেখে নিন ওটা।
Very well. I'm grateful, my lord.
One submission, my lord.
I'm grateful, my lord.
It was district until number 22 on Monday, and your lordship was pleased to pass over the matter. There is some urgency. The next day is 21st of July. Fixed in the
21st of July is.
Grateful.